please, Your Lordship. So item number 28. We were supposed to file our affidavit in this matter. With the consent of the other side, may I pray matter be taken after vacation? In the meantime, we'll file our affidavit.
You are for the IOCL.
Yes, Lordship. All the parties.
Mr. A. Sharma, Standing Counsel, IOCL, submits that, prays that he be granted further 3 weeks' time to file his affidavit in the matter. File an affidavit on behalf of the respondents represented by him in the matter. Prayer is not objected to by Mr. Das, learned M.K. Das, learned counsel for the petitioner. So accordingly, the registry to list this matter after 3 weeks on a date to be fixed by it.
May I please, Your Lordship? Lordship, with the consent of other side, I beg to mention item number 52, my lord. My lord, the matter may be come up immediately after vacation, my lord.
Why?
My lord, I need some clarification from the department, my lord.
This is that matter relating to that check.
Hi, ma'am. Yes.
Why is it pending?
Sometime maybe I have taken consent from the other side also, my lord. Immediately
Mr.
after
P.S.
vacation.
Bhattacharya, learned counsel for the petitioner, prays that he be granted further 3 weeks' time to complete his instructions in the matter. Such prayer is stated to have been made with the consent of the consent of the opposite party, reviewed Maribade. So, registry accordingly to list this matter again after 4 weeks on a date to be fixed by it. 53 Mariba, list this matter again for 4 weeks along with review petition number 80 of 20.
May I, Your Lordship? Lordship, item number 49 and 50 of today's list, Lordship, have taken the consent of the other side. Lordship, in this case, senior counsel Mr. K.N. Chaudhary is not available today. Can it be after the vacation?
Mr. M. Das, learned counsel. You are M. Das or M.K. Das?
M. Das, Lordship.
M. Das, huh? Yeah, I got M. Das, good. M.K. Das, Mr. M. Das, learned counsel for the petitioner.
For the respondent number 7.
In both the cases?
In one case, Lordship. In the second case, in 50.
In WPC number 117/2021, that he be granted, that the matter be adjourned on the ground that the arguing counsel is not present.
Not today.
Such prayer is stated to have been made with the consent of the learned counsel for the petitioner. Also, registry accordingly to list this matter again after the ensuing vacations on a date to be fixed by it, along with WPC number 45568/2021.
Obliged, Lordship.
May it please, Your Lordship. Lordship, item 20, my lord. Here I am supposed to file, my lord, replies. So I am paying further sometime.
Mr. M.R. Khandakar, learned counsel for the petitioner, prays that he be granted further 4 weeks' time to file his reply in the file a rejoinder to the affidavit filed by the respondents. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again after 4 weeks on a date to be fixed.
May I please, Lordship? I beg to mention item number 58. As per
58.
Yes, as per office notes dated 8/12/2025, service report upon respondent, private respondent number 8 is awaited. Kindly this matter be listed after winter vacation.
Registry to await service, it would sound 58 to some. Registry to await service, completion of service upon the respondent number
8, private respondent.
8 for further 3 more weeks.
Deeply honest.
May it please, Your Lordship?
Yes.
May I beg to mention item number 63. In this matter, we were supposed to file our affidavit in opposition, my lord. With the consent of the other side, I am praying for listing of this matter after 2 weeks.
You are for the
Respondent number 6, Your Lord. Today we will be filing in due course of the day, Your Lordship.
Who has mentioned this matter?
To the petitioner councils.
Then
But-
why have they given the consent?
Yes, today they have given the consent.
Why? Because they have mentioned the matter, it has come up. Why have they mentioned them?
We have informed them previously regarding that we are going to file our appeal in opposition. So if your consent is there, we'll be mentioning the matter before your lordship. They have given us the consent.
Mr.
MZ Rahman on behalf of Mr.
MZ?
Jayabedin. MZ Rahman,
MZ Rahman, Learned Counsel, representing the respondent number
6.
prays that he be granted for the 6 weeks' time to file an affidavit in the matter on behalf of the respondent represented by him. Prayer is not objected to by the Learned Counsel for the petitioner. Registry to list this matter again after 6 weeks on a date to be fixed by it.
Much obliged.
May I please, your lordship, I beg to mention item number 65 of the supplementary list, your lordship. In this case, we need further time to obtain instructions and to file our counter affidavit. Lordship, we have to file our counter affidavit.
You are for the
Customs Department, your lordship.
Learned Standing Council Customs prays that she be granted for the 4 weeks' time to complete her instructions and file an affidavit in the matter. So prayer is not objected to by the Learned Counsel for the petitioner. Accordingly, registry to list this matter. Have you taken the consent?
Yes, your lordship.
Registry to list this matter again after 4 weeks on a date to be fixed by it.
Obliged, your lordship.
May it please your lordship, with the consent of the other side, I beg to mention item number 29. The leading counsel in this matter, Mr. Didas, is out of station for public purpose. The matter may be taken up after winter vacation.
You are for the
Petitioner.
A prayer is made on behalf of the petitioner for an adjournment in the matter on the ground that the arguing counsel is not in town. Also, prayer is not objected to by the Learned Counsel for the respondents. Accordingly, registry to list this matter again after 4 weeks on a date to be fixed by.
Much obliged.
Okay, item number supplementary release, item number 63. The other side has prayed for adjournment today. So the matter is yet to be admitted.
Why have you consented? You had
Yes.
got this matter listed after applying
We
before
have
the
no
registry.
conditions to be made, your lordship, because
Can't help it. He said you have given consent.
no, lordship, exactly, we have not given the consent. We have said if the court allows,
Yes,
then
they did. The
They made a
conducting council,
prayer,
the
solely
conduct,
allowed.
they
so
have
my
called the
senior
other-
informed the conducting council of this.
they have called the other council. The other council has said that to consult with me, but I didn't get any call in regards to this.
What
So
is this?
Conducting council
Who is
was
the man who had taken the permission? Who is the council who had taken the permission?
my senior Mr. Jayabedin.
Ask him to be.
Yes,
We'll take
Lordship.
up when the matter reaches.
yes, lordship, it may be hard, your lordship.
Lordship, we are filing in due course of the day, then records may be called for and the matter may be taken up at 2. We will be filing.
You can't dictate everything, Mr. Council. You have said that you have taken the consent.
Yes, we did, your lordship.
They said they are
They have
disputing
made a
it.
call to the other
They are
council.
disputing it.
The conducting council was informed, but the other councils of their chamber is appearing now.
What have you informed? That had they consented to that giving time?
Yes, the conducting
Then-
council
then-
has
then-
given
then
consent.
get both
Okay,
the
my senior is
councils.
appearing.
We'll see. We'll see. We'll see. Let the matter be called up.
Yes, all right. Oblige, your lordship.
This is not done.
Section ভিতর আছে নাকি?
Yes. Wait for some more time, they are processing.
I need 2 minutes.
Heard Mr. Kayum, learned counsel for the petitioner. So DA Kayum. Also heard Mr. J.K. Goswami, additional senior government. Some appearing for the respondents. Mr. Goswami, in terms of the queries raised by this court, while the order dated 8/12/2025 has placed on record a communication dated 10/12/2025 received by him from the Secretary to the Government of Assam, Women and Child Development Department. A perusal of the said communication would go to reveal that the matter pertaining to the release of the dues of the petitioner is at an advanced stage of processing and awaiting the final approval of the competent authority. So, the said communication reveals that on the said approval being obtained, the Finance Department would be moved for a release of fixation of ceiling, na? FOC fixation of ceiling.
Lordship.
Fixation of ceiling, bracket FOC. And thereafter, the money would be drawn and subsequently would be deposited in the account of the petitioner herein. Also, in view of the above developments taking place in the matter, this court defers the final consideration in the present matter and directs the registry to list this matter again on (21/1/2021), 26. So on the next date of listing, Mr. J.K. Goswami, Additional Senior Government Advocate, Assam, shall receive updated instructions with regard to the progress made in the matter Full stop. A copy of the communication dated 10/12/2025 furnished by Mr. Goswami is kept on record and marked as X for the purpose of identification.
Lordship.
Published.
Lordship.
May please. The last occasion, my lord, this honorable court, my lord, find as regards the, my lord, second marriage, my lord, page 33, my lord, lordships, peruse the page 33, my lord. So, my lord, serial number 1, my lord, is written as second wife of so and so, my lord. My lord, death, my lord, is a part of the, my lord, succession certificate, and the death, my lord, is a post title, my lord. If lordships kindly turn to page 20, the petition filed by the, my lord, respondent number 9 before the, my lord, learned district judge, my lord. Page 20, lordship will find.
Yes.
Page 20, my lord.
Who is appearing for the respondent?
My lord, on the last occasion, Mr. C. Borua, my lord, for AG, my
I'm
lord.
for accountant general.
Mr. Borua had appeared
Lordship.
for Accountant General.
Lordship.
He appeared for Accountant General.
My lord.
Who is appearing for the wife?
Government, my lord. Wife,
Hmm?
wife, none is there, my lord. Respondent number 9, my lord, none is there, my lord.
You have released the
So, Your
pension-
Lordship, there is a- interim order is there.
interim order. Is there?
That's
22/6/2015, my lord.
Page,
My lord,
page.
Lordship, Lordship may pares order dated 12/6/2025, Your Lordship.
22.
Where is the order of the permanent Adalat?
My lord, that lordship will find page 30.
But before the Look Adalat,
My lord.
the matter proceeded that she was the first wife and you were the second wife.
That is not an observation in the order.
Need not be, but it's there. You accepted that. What is your plea to that paragraph? Okay.
But
That
my lord,
paragraph,
In
plea,
the,
what is your reply?
but my lord, the applications has been filed by the my lord respondent number 9 before the my lord Loka Adalat for my lord
I know that.
dividing the my lord.
I know that.
my lord.
Niru Hazarika is respond number 9.
My lord.
She had made a categorical statement in para 3. What is your reply to that?
There are 3 of.
The page 21. The complaint petition before the mixed succession case.
Yes. My lord, I have, my lord, filed my written objection as page 24, my lord. Page 25, para 4, my lord. Page
You
20
come to para 3 of page 24.
It is the, my lord, statement of the, my lord, my husband, my lord. My
Got it.
husband-
That indirectly shows a marriage was there. Proves the earlier thing.
But, my lord, that is the, my lord, information, my lord, provided, my lord, by the husband. But there is no any, my lord, declaration to that effect by any complaint.
Okay, go and get a declaration from the civil court.
But my lord, if lordship find the page affidavit filed by the my lord, respondent number 6, 7, and 8, my lord. Paragraph, my lord, 8, page 49, my lord. Lordship may kindly, my lord, page 49 now. Para 8, my lord.
Hmm.
As regards the aberration made in paragraph 8 of the petition, the answering deponent states that the answering respondents rightly and duly followed the directions and orders of the in the aforesaid missed succession case number so and the petitioner's names was included for the purpose of family pensions in the revised form number 10 and forwarded to the accountant general office Guwahati for necessary action by way of letter number so dated so. The answering deponent, however, cannot comment why the letter input number so dated 13/5/15 was issued.
Show me the records. This is different. They say
My lord, my
that only respond now. Naturally, only one will get.
no, that's true, my lord. But my submission is that, my lord, since my name has been, my lord, forwarded.
No, your name has been forwarded as one of the claimants for that.
But that's
Let
why,
me
my lord,
just check up.
whether, my lord, my name has been nominated by the deceased employee, my lord.
This is the first wife, second wife. That is the proposal.
But this,
She will receive the amount. She will give it to you. If you don't get, go before the family court for maintenance. We'll provide for that. That even if respond number
my lord,
9 gets it.
my lord, this is the nomination paper, my lord. Because the one, my lord,
No, this is the proposal.
no, my lord, 137(6) rule, my lord, in the,
Nomination is only you are there as a agent
yes.
for the trustee, for the others. Now the respondent number 9 would be the trustee being the first wife and she will receive the
Whether-
pension.
Whether, my
She
lord,
will transfer 50%.
whether, my lord, the service record of the deceased, my lord.
That you show, you demonstrate.
My
Why
lord,
should
that-
I demonstrate?
That,
You make a demonstration. Everywhere you go and say that she is the first wife, you accept that proposition.
my lord, there is no, my lord, specific admission, my lord, but that information is provided by the, my lord, my husband.
Now we can't also ask your husband.
No, there.
He is beyond our jurisdiction now. Sorry. Let the respondents only say that your name was also incorporated, and why it is only being paid to the respond number 9, they don't know. Naturally, they don't know anything. But Mr. Sharma knows, and this court is expected to know.
That, my lord,
What, dismiss?
that so far the, my lord, the child is concerned, they are entitled till they attain majority, my lord. That
You
part-
will get everything. If they don't pay, then your only way out is proceeding before the
Civil.
civil court. Because that law has been laid down in respect of the Muslim marriages, that will equally apply to this. It's a division bench order. I'm bound by that. What do you say? Want to have the period of vacation for appeal, or after the vacation we pass the order?
my lord.
Choice is yours.
As lordship deem fit, my lord.
After vacations. Not disturb him during the vacations. Heard the parties at length. Mr. R. Sharma, learned counsel for the petitioner, submits that the petitioner is the first wife of late
Tilak Chandra Rao.
Tilak Chandra
Rao.
Hound. However, from the materials brought on record, it is seen that in the proceedings held in connection with missed succession case number 11,
My lord.
11 of 2012, it was the respondent number 9 who had projected herself as the first wife. So, there is no material brought on record to determine as to between the petitioner number 1 and the respondent number 9, who would be the first wife of the deceased government employee. Petitioner, the petitioner number 1. So, post with the above situation, Mr. Sharma submits that the matter be taken up after the vacations, enabling him, facilitating him to prepare, to make further submissions in the matter. Prayer accepted. Registry to list this matter after the ensuing vacations. Nam likhi diva sore. Very good idea.
Record certificate.
No.
Acknowledgement.
No. May it please the loss. If your lawsuit kindly takes up the second matter first, madam. I beg to.
I have already heard this matter. What is more to be heard here, Mr. Bormia? Yes.
I beg to refer, my lord, to page 65 of the second petitions, my lord, judgment of this honorable court delivered by Honorable Justice Michael, my lord.
Yes.
Here in this case, my your lordship kindly see, the learned government side is always referring the Devotos Tavares judgment, my lord. But this judgment delivered by Honorable Justice Michael has dealt with the matter, my lord, and may I read it before your lordship?
You can tell me which relevant paragraph. Which paragraph you want to read?
Page 74, my lord, paragraph 9, my lord.
This is not, okay, fine. Okay. Yes. But here again in paragraph 10, the Supreme Court, the coordinate bench says that such consideration would be in the light of Devabrata Tiwari.
Yes.
And when will this consideration come? When we are convinced that the application, the reasoning assigned by SLC is not correct, then only the matter can be remanded back.
My lord, this paragraph has, I like the phrase, my lord, all are set aside, my lord. Paragraph page 74, my lord, paragraph 9.
Hmm.
And Roman 1, my lord, if you read it, whichever been last line, my lord, the rejection of all compensation appointments by the DLC SLC, which have been put to challenge and are pending in the Guwahati High Court as on 3/4/2025 are set aside. So ours is, my lord, 2020.
Yes, madam, what is this?
Lordship, kindly consider the date of death, Lordship.
No, forget it. Here, what is the court saying? Ordinate bench has said 9-1, which have been put to challenge and are pending, page 74. In the Guwahati High Court as on 3/4/2025 are set aside.
3/4/2025.
So this case need not be considered. This case need not be considered because this has already been pre-considered.
It is already been considered, Lordship.
No. The judgment at page 74.
Yes, Lordship.
Also takes into account this case.
Lordship. Yes, all the applications for compassionate appointment submitted by the petitioner shall be considered and disposed of by the concerned DLC, Lordship. Then, Lordship. Paragraph 10, Lordship. It is made clear that in view of the consent of the parties, the court has not gone into the merits of any of the petitioner's cases that are being disposed of by way
That
of
is
this
the answer.
order.
That is the answer. Okay. The answer. The answer is there. This is not a case on merits, not by me. It will have no binding effect on me because this is not a case decided on merits. It's on the consensus of the parties. You convince madam to also concede, I'll pass the order. Otherwise, if she is objecting, I can't.
Then next judgment also delivered by this honorable court, my lord, Justice Jamil, my lord, page subsequent to that, my lord.
Hmm.
Paragraph 5 at page 79, my lord. The learned government advocate, Ms. So-and-so, submits that as the petitioner had earlier approached this court by way of so-and-so, and by the order it is passed in the writ petition, the case of the petitioner was remanded back to the SLC for a consideration. And further taking into consideration the order that is so-and-so passed in WPC number so-and-so, a batch of other petitions, the case of the petitioner can now be considered by the SLC in its next meeting sitting. Accordingly, recording the submissions made by the learned government advocate, this writ petition is disposed of directing the SLC to consider the case.
These are all on the basis of concessions by the government advocate at page para 5. Para 5. That is not by me. Show me. I'm with you.
Maybe consider. And above all these things, my lord, may I draw your lordship
When is the
attention?
death of the father occasioned in your case?
And
date?
above all this, my lord.
No. What is the date, Mr. Marudubuya? What is the date of death of your father?
Date of 1976, no? Sorry, 1997, my lord.
1997.
28 years.
So how many years have
No,
passed?
only
Them?
the-
20. No. Today, I'll have
28
to
years.
direct them to consider your case. Now, if I have to direct them, I must be satisfied that I can issue a mandamus.
In this respect, my lord, I beg to draw your lordship kind attention to the judgment delivered by Honorable Justice Mehdi, my lord, which is discussed the unfortunate fate of the boy, my lord, because some fraudulence are done by a imposter, because of which there was the delay caused, and this honorable consecutively in 3 judgments. First judgment delivered by Honorable Justice
All
Pujjal Bhuya, that
have spent their force. All those orders have spent their force. This is a fresh consideration before me.
this
And the only thing I have to consider is whether I should have compassion.
For drawing your lordship compensation.
That
madam,
much only. If I can generate compassion, I'll pass the order. If I can't, 28 years afterwards, I can't.
Of course, man.
I can't.
In this respect, I just make your.
This is not your right, Mr.
Of course, I have no right, my lord. But the judgment delivered by Honorable Justice Mehdi was not at all considered. May draw the impugn order, page 56 of the past petition. Page 50. Page 56 of the first petition, man. The impugn order, it is against the name of Merabuddin Lashkar, man. The application was placed 12 years after the demise of the government employee, so the proposal does not fulfill the requisite criteria as per the point so and so. My lord, it is in absolute non-consideration of the judgment delivered. All these things are covered by the judgment delivered by Justice Mehdi, my lord. In this respect, I draw to your lordship attention the page 76 of the lordship's judgment, paragraph 14, my lord.
Of?
First petition, man. First petition.
Page 70?
Page 76, man. 46, my lord. Page 46, paragraph 40. I just like to read out 3-4 paragraphs for the losses, my lord.
This is of 2017 lordship. Thereafter, there are number of cases has been dealt on the compassionate appointment lordship.
All these things are considered.
This is of 2021. At that point of time, the decision of the Honorable Supreme Court in the case of Debabrata Tiwari had
Yes,
not come.
Lord.
Was not there, man. This
So after this, I'll have to factor in that also.
So my humble submission, my lord, the impugn order, they did not at all read out the judgment. Had they read the judgment, my lord, these things, this order would not have been appeared.
My sympathies are with you. It's not that I am getting some pleasure here in doing this, but I can't go beyond law. We have to be harsh, can't help it.
Just leave it before the loss. That
you.
point.
2 o'clock for delivery of law.
Deeply obliged, lordship.
I'm sorry, I'll dismiss it.
My lord,
2 o'clock.
kindly, my lord, I may be refer additional affidavit. It will submitted
You have submitted? When?
earlier, my lord.
Lordship, they have brought on the SOP and this one lordship of August 2025. After the
Second case you filed.
after the judgment delivered in the common writ petition lordship, certain directions were passed lordship, as the judgment has been referred by the senior friend of the petitioners counsel lordship. So thereafter,
Only, my lord,
because there was a direction to the government lordship, and accordingly this SOP has been issued and applications were called whose cases were pending as on that date lordship, giving a certain time frame lordship for application. So this has been made and accordingly these will be considered lordship.
Now, in such consideration, if you allow cases which are there, say 2002,
Yes, lordship.
1998, why will the petitioner should be denied?
98 because is
No, why have you not gone up on appeal?
and my lord, on the basis of this, my lord, this day before yesterday, this judgment is passed, my lord, another coordinate bench, my lord.
ना देखिए yeah 2008 death of 2008 it's of 97. I just don't know, sir.
You have
Lordship,
submitted an
how-
application here also.
Yes, ma'am.
You have submitted.
Submitted.
Huh? Then that will be considered.
If submitted, then this will take its own course,
That will
Lordship.
take
Then
its
why
own
they are
course.
pursuing this one,
We
Lordship?
are
no.
dismissing this.
No, Lord,
But
here
Why
we
they are
have
pursuing
submitted
this, Lordship?
in
If
terms
they
of the
have,
benevolence of the government,
Yes.
so you will.
Here, my lord, lordship, kindly, my lord, he is. my
they have to,
lord,
then sir,
kindly,
both
my
the,
lord, my lord, kindly, my lord, honorable.
I'm not going to lay down a long law.
No,
I'm
my lord,
sorry.
Honorable Michael, my lord, my justice, my lord, Sanjay Med, pass the judgment, my lord.
You go upon appeal. I'm
Yes,
passing
my
the
lord.
order.
Yes,
You
my
go
lord.
upon appeal.
My lord,
Anyway, you are a
and
veteran. The petitioner
lastly,
is a veteran.
lastly, my lord, observe that, my lord, that should not be taken as a precedent. Honorable, my lord, justice, my lord, Sanjay Mehdi, my lord, observe that, my lord, this is the delayed matter, my lord. Normally, that kind of order should not be passed, my lord. But because in his place, my lord, another person was already appointed. Therefore, my lord,
That
being-
matter was considered by this court. The court did not give you any benefit initially.
in-
My Lord Justice Bhuyan's order. Interference was made with the appointment, but the consequential relief that ought to have flowed to you,
this
it was
was,
not given. So that is the end.
consideration, my lord, your lordship's observation is also binding, my lord. Under what circumstances your lordship directed to consider? That to be, my lord, looked into, my lord. Here, my
I
lord,
filed a contempt. At that point of-
consideration came, my lord, in my favor, my lord. When, my lord, lordship, kindly I may be allowed to submit, my lord, two things.
Did I prevent you from
No, no.
allotting? I think I have posted this matter at your
Yes,
instance
my lord.
for
Of
around
course,
7-8 days.
I am thankful, my lord. But here, my lord, consideration came why, my lord? Because, my lord, it was found that, my lord, another person was, my lord, appointed.
For Bhuya, my only question is, after 28 years have passed down, what is the compassion that is left?
My lord, here, my lord, there already this honorable court.
You have
that-
survived, you have moved on.
And, my lord, another, my lord,
What is your age now?
age, my lord, now, my lord, 37, 38, my lord, because he was there minor, my lord. Lordship may reject it, my lord, and my lord, allow it, my lord, but allowing judgment would be more healthier, my lord, than, my lord, rejection, my lord. Because, my lord, here, my lord, when, my lord,
2
honorable.
o'clock. If some compassion is generated, 2 o'clock, I'll think
Just
about it.
with folded, my another submission, my lord. Suppose, my lord, your lordship directed to consider, can DLC considered in my favor?
You can be with
Subsequent-
folded hands, with folded fist. That is your discretion.
No, lord.
I'll only hear what you are saying.
Great, my lord. No, my
I'm only
lord,
hearing what you are saying.
Lordship, if
Well,
the petitioner
well,
is
my
of
lord,
32,
SLC.
age of 32 now, Lordship, then at the age of 4, Lordship, he has
I
applied.
know that.
Yes, yes,
It
yes.
will be reflected
Then
in
this,
the order.
yes.
Then, my lord, if the direction of your lordship, if DLC considered in my favor, my lord.
2000 volume 7 SCC 715 or 215. Check up.
Constitution.
It's a case of a son of a college employee. Supreme Court said that post cannot be kept vacant till the
Yes,
man
this is their-
attains.
In
This is
majority.
but
Thank you. I think I have heard you enough. Reserve your energy for the next round. I'm dismissing it.
Kindly, my lord,
Only at 2 o'clock.
consider, my lord, let the, my lord, this matter be ended ceremoniously, my lord. This honorable court, my lord.
The law boy has destroyed his life, keeping a hope for this case. I don't want that to continue.
My lord,
He is 32.
my lord.
He is there. He still has time.
My lord,
He will get a.
net submission is that, my lord. My lord, this honorable court also, my lord, provided that, my lord, when SLC will consider the matter, my lord, principle laid down by the honorable Supreme Court, my lord, in the Devabrata theory should be also, my lord, taken into consideration, my lord. Therefore, my lord, this matter may be ended, my lord, ceremoniously. Let the matter be considered by the
See,
SLC, my lord.
you have a ground of appeal even before the order is passed.
No,
right?
no, my lord.
Because I'm going
Admitted,
against the coordinate benches.
Your lordship can pass.
I
this
am
order.
going against the coordinate benches order, three
No.
coordinate benches order. You have a ground of appeal
Admitted,
already.
my lord. I know, my lord. If you don't admit, your lordship is also ever, my lord.
We'll
but
consider 2 o'clock. 2 o'clock. 2 o'clock.
Ceremoniously, my lord.
We do
Devabrata-
everything ceremoniously.
Yes, my lord. SLC, my lord, kindly, my lord, SLC may
Even
be
we
rejected. my lord.
dismiss a case, we do it ceremoniously.
Yes, my lord.
Allow a case also ceremoniously.
SLC, my lord.
Because
SLC will, my lord, look into that.
we are equivalent. We have nothing this side or that.
Similar order, my lord. Kindly, my lord, SLC will consider, my lord.
No.
The overall Tiwari, my lord. Kindly, lordship, yet to fear.
Who will dismiss it? And no arguments. Yeah.
Offline.
Wait, please, your lordship. Your lordship has already heard the matter.
I'm only to pass my orders. We'll pass the orders. Second of it. We'll pass the order. Second. I'll pass those two orders, then I'll pass this order.
May please, your lordship. We have instruction to withdraw the case, lordship.
Ms.
All India Limited.
Ms. Musahari.
S. Musahari, Learned Counsel for the petitioner, also heard Mr. A. Sharma, Learned Counsel representing the respondents number 1, 2, 4, and 5.
Yes, your lordship.
Madam, your name?
I'm here on behalf of K. Borua.
Ms. M. Bhuya, Learned Counsel representing Mr. A. Borua. A. Borua appears for the respondent number 3. Who is respondent number 3?
Three is the lady,
Lordship.
the complaint.
Complaint. Also, on the last date of listing, the Learned Counsel for the respondents number 1, 2, 3, 4, and 5 had placed on record a order dated 24/5/2021 issued by the disciplinary authority of the petitioner, imposing upon the petitioner a penalty of censure on conclusion of the departmental proceedings instituted against him. The same having been brought on record, an opportunity was granted to the petitioner's counsel to complete her instructions in the matter. Today, the Learned Counsel for the petitioner on instruction submits that the petitioner desires not to press this matter any further, and accordingly she prays that she be permitted to withdraw the writ petition. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, writ petition stands dismissed on withdrawal.
Pleasure, lordship.
May please, sir. On the matter was being referred before the arbitrator, mediator lordship. On 24/9/25, the attempt was made, but now the parties appeared. Accordingly, it failed. And the matter is before your lordship.
My lord, partial amount, my lord, of the retirement benefit paid, my lord, but my lord, a family pension not yet being, my lord, paid. Family pension not being paid, my lord, and it is 15 years has
In
passed,
that
my lord.
regard, lordship, I have one instruction dated 14 July 2025. Which says, especially cases in regard to family pension and other benefits, lordship, gratuity, DCRs and everything. Which says, lordship, details of final payment which were already paid to the family members are as under. If lordship wishes to say, I can provide it,
My lord,
lordship.
we are also not informed what amount, my lord, remain to pay. We are not
Inform means you have to get the instruction from your clients if you are.
No, line in the passbook, my lord, amount credited, but my lord, they have not the.
Now, has the PPO been issued? Family pension has been awarded, granted?
Lordship may kindly see.
Who are you? You are the? Who are you, Mr.?
My lord, the
Son.
two sons of the second wife,
Second wife. How old are you? 23, 22. You are already major.
my lord, major, but my lord, my amount, my lord, from 2010 to 2022 and 24 remain to pay, my lord, that is share of pension, family pension.
Who has received that amount?
My lord, some amount received by the petitioner number 1, and my lord, this respondent number 5.
Respondent number 5 is the father.
It is respondent number 5 is the, my lord, first wife.
Okay. And the first wife, and who has received? First wife and?
First wife and the petitioner number 1. And petitioner number 2, my lord, receive a little amount, my lord, but we are not, my lord, in the.
I don't
information-
understand. Why have you filed this case? The family pension has been paid.
My lord, we are not aware because.
Yes, what is the position?
Position is lordship, lordship may kindly see this one. We have already para number 3. They both moved to a civil court. Civil court passed one order to bifurcate the family pension by 50-50% and other benefits in 60% or 40%. Accordingly, we have paid by following the order of the civil court.
These are, my lord, with the consent, we are not against the, my lord, succession order.
Etu kotha na, etu kotha.
Yes, payments have been made to the family.
My lord, this petitioner number 2 supposed to get, my lord, more amount than the petitioner number 1 because, my lord, he is the.
So there is a dispute between petition number 1 and petition number 2.
No dispute, my lord.
Go to the
But
civil.
they did not appear before the mediator.
No, my lord was sitting was there in the before the register, my lord, here in the court, my lord, it could not be resolved.
So may see the report of the mediator, lordship.
My lord, let him inform that what is.
Why should he? He has already informed. He had got everything.
I am not aware, my lord. No copies are to.
You are not aware, your clients are aware. They have
My
not
lord,
briefed you.
Client has not been given any.
No,
document, my
client
lord.
has been given in July,
That's right.
in
my
July
lord.
2025.
My lord, and first my saying, my lord, this partial amount has been already paid.
No, full amount. 9 lakhs to Rajdip, 1 lakh to Sagar.
Sagar supposed to get more amount, my lord.
From
because
whom?
He was younger.
From whom?
From the, my lord, is the family, part of family pension.
That was taken by Rajdip.
My lord, then my lord, this copy, my lord, maybe give it to me, my lord, I am not.
We'll take it up at 2. Give him a copy. I'll get your instructions. Give him a copy.
My lord, regular family pension is not.
You're not going to get it.
My lord, I'm not, I am, but my respondent, because my lord, they are in, my lord, amicable now. They are, my
How
lord,
can a boy after attaining majority get family pension?
my lord, the boy, the first wife is not getting family pension, my lord.
Your second wife,
I'm, second wife is not here, my.
you withdraw this case, first wife will get the pension. You withdraw it.
My lord, second wife, my lord, he paid, my lord, then matter even there.
Copy,
And
copy. Give him a
My
copy.
lord, this Pusilal, my lord, who appearing for respondent number 5 and 6, is my lord, about 10 days, my lord, he expired, my lord.
Huh?
So, expired, my lord. The advocate expired, my lord.
Oh, Pusilal.
5 or 6.
When?
10 days ago, my
What happened to him?
my lord, he was suffering from cancer.
Oh my good God. He was appearing before me
Yeah, right, my lord.
4-5 months back.
You are right, right.
True.
So, my lord, if my lord,
I didn't know.
after 1 week or 2 weeks, my lord, then
It is Mr. S. Chauhan, Learned Counsel for the petitioner, submits that the Learned Counsel representing the respondent number 5 and 6 is no more in the world. So, accordingly, he prays that the matter be taken up after 10 days. A copy of the instructions received by Mr. C.K.S. Borua, Learned CGC, shall be furnished to Mr. Chauhan, who shall, on the next date of listing, apprise this court about the stand of the petitioners with regard to the same. Registry to list this matter after the ensuing vacations.
Must be.
Patna ke na lora hai. Sanjay.
Please,
Puro kora deu. Sudesh Singh. Allah what kore. Pushilal bole Patna ke lora duke degi.
please, your lordship.
That's casing on sir.
Please, your lordship, the learned counsels are on legs. Can this matter be taken up after 2 weeks?
They will be in legs for continuously
No,
for
Your
2
Lordship.
weeks. Who is on legs?
Lordship, Mr. D. Upamanyu.
You will be relying on the decision of my Lord Justice Medhi, or it will go against you.
My lord,
This is a fight
that
between
was-
GNM and BSc
that
nursing.
was with regard to the combined garrison list.
Ah,
But here, it's an individual promotion case, my lord, which is been followed by the department since the inception, my lord.
you are a GNM.
I am a GNM.
Who has superseded you?
No, nobody has superseded, my lord. They have promoted me to the post of my lord superintendent. Then without issuing any notice,
They have reverted you.
they reverted me saying that I should have been in the cadre of assistant nursing superintendent, then only would have entitled to the post of superintendent. But though in my promotion order, it is mentioned as assistant nursing superintendent, but I worked as assistant superintendent.
But you worked as superintendent.
But I have clearly said, my lord, and that is the direct promotion, my lord. I have not.
Where
less
is the
than-
order? Promotion order?
Promotion order, lordship will find at page 34.
There is an interim order here?
No, my lord. That was the problem, my lord.
You were before this promotion holding the post of?
Before holding my initially the staff nurse,
Then what sister? What in charge?
then my lord, they promoted me assistant nursing superintendent. But then,
Directly.
yes, that is the next, my lord.
Okay.
And my lord, in fact, in the training center, there is no post of assistant nursing superintendent. It is assistant superintendent. So far as the college and other, my lord, clinical
Assistant
stuff,
nursing superintendent,
nursing
deputy
superintendent.
superintendent.
It's, my lord, synonymously, they used to use, my lord, the word.
Hmm.
And I continued in the, my lord, the training center in Sabua, considerable period, and thereafter I have been promoted.
What is your length of service left, or you have some service?
Lordship.
We'll have it immediately after the vacations. Sir.
An observation for disposal.
It is stated that the pleadings in the matter is complete. You're not filing any rejoinder.
No, it's complete, my lord.
You have filed your rejoinder.
Lordship.
Oh, counter affidavit by.
Pleadings are complete.
Pleadings have been completed in the matter. Accordingly, it is prayed that the matter be taken up for final disposal. Also, the registry to list this matter again on, give me a date.
6th of January, my lord.
Let it be 8, not immediately on opening. 8, you have any problem on 8?
In that case, my lord, can be 26th, my lord.
26, okay. 26 will not come.
27.
27.
Okay.
On
Okay.
27/1/2026, an endeavor would be made to dispose of the matter on the next.
Okay.
May I please your lordship? Lordship, on the last occasion, the respondents were directed to file an affidavit. However, the same is not on record.
Today morning, I have received some instructions, my lord.
Ms. M. Borma, Learned Counsel, appear representing the government.
My lord.
File it on affidavit. She should also know.
I need some more time because,
Fine. After
Okay.
vacations.
Lordship.
Lordship, one more submission. Lordship, on 5th of July 2025, the petitioner number 5 expired.
Oh.
Regarding the same, we have filed a substitution petition, which is not on record. We have filed that.
List along with that.
Ms. M. Borman, Learned Counsel, Learned Government Advocate,
Yes.
representing the state respondent, submits that she has received the instructions and would be filing an affidavit on behalf of the respondents represented by her within a period of 3 weeks from today.
Correspondent number 3, and as per my instruction, we have already vacated the.
You have already vacated the land.
Yes.
Okay. The learned counsel representing the Water Resources Department submits that the land occupied by the department has since been vacated. Full stop. Ms.
J. Sharma.
J. Sharma, learned
behalf-
counsel for the petitioner submits that during the pendency of the present proceeding, the petitioner number
5, Your Honor.
5
Lordship.
has passed on,
37,
comma, on 37
2025.
3725 and a substitution application has already been filed. Also, raised it to list this matter again after 3 weeks, along with the said interlocutory application stated to have been filed by the petitioners in the matter. The learned government advocate shall invariably, before the next date of listing, bring on record the affidavit of the state respondents.
My lord, may kindly fix a date if possible. The vacation.
Twenty-eight.
Lordship.
Deeply obliged.
28.
Obliged, Lordship.
Your Lordship, please pass over the matter for the time being.
Anything?
No, my lord, my lord has already heard. The my lord. Today it was supposed for my disposal.
Pardon
Alright.
hearing. Sir, please pass over the matter for the time being.
Time being. Yes, Mr.
That matter, my lord, that post office matter, my lord, that Kisan Vikas Patra. May it be taken, my lord, any other day. My lord, let me find out something, my lord, if I.
That is why I permitted you today.
My lord,
Last occasion,
yes, your lordship may take up the matter, my lord, but after vacation, my lord, let me find out, my lord, if I get anything, my lord.
not for your client, I'm doing it for you so that you can
Yeah.
peacefully enjoy your vacations. On prayer of Mr. B. Sinha, the hearing of the case is deferred. Registry to list this matter again on 7th,
Obliged.
2026 for further hearing.
Let me don't,
Will do. Any problem on 7-1?
my lord, on 12, my lord, 12, my lord, because the
12, we are not coming. That whole week, I'm not coming.
7. Or 13 then, my lord.
No. That whole week is closed.
Oh, sorry,
Vacation,
sorry.
Bihu.
Oh.
You'll not be here on 7th.
No, because just after reopening, we may not be, because we may.
Okay, when 19, 20, 21,
Yes,
22,
my lord, yes, my lord.
22, Didier. 22,
Oh,
22, 1.
yes, my lord. Obliged, my lord.
Your Honor. Your Honor, I'm appearing in item number 15. Kindly the matter be taken up after some time, Your Honor. Time
No,
being.
after some time. On the prayer of the learned counsel for the petitioners, a registry to list this matter again after the ensuing vacations on a date to be fixed by.
There is an interim ordering.
Interim order passed earlier to continue till the next date of list.
Made with the lordship, my lord. We challenge the direction to remove the wall, my boundary wall, my lord, that is that.
They were supposed to file an affidavit.
Yes,
They-
my lord.
They
They
filed.
said they had the instructions and they will file affidavit and they took time on that day.
Who is Ms. A. Bhattakur?
I think Mala, she was assisting Nayak, P. Nayak.
But Mr. B.D. Goswami, learned counsel for the petitioner. On the last date of listing, the learned counsel representing the GMC authorities had submitted that the instructions were received and the affidavit would be filed within 2 weeks. Also, the records do not reveal filing of any such affidavit. Also, considering the nature of the dispute arising in the present proceeding, a last chance is granted to the authorities of the GMC, Guwahati Municipal Corporation, to bring on record their affidavit on or before 9/1/2026. Registry to list this matter again on 19/1/2026.
My lord, can we have it after 19th, my lord?
When, you tell me.
19th, or no, after 19th, my lord, 21st.
Give me a date, Mr. Goswami,
21st.
whenever it's convenient to you.
Huh?
20,
21st?
21,
21st.
21 board is in it.
21st. My lord, there is an interim order on that.
Interim order passed earlier to continue until further orders.
Must-
It's been more than 2.5 years since I've retired and my pension has not been released. The reason assigned for denial of pension is also perverse, my lord. It's on the.
Have you gone before the
mediation?
mediation?
Mediation has failed, my lord.
Failed.
Failed. Now, my lord, the reason which has been assigned is at page number 85, running page, paragraph 5. Paragraph 5, my lord, page 85. They say that it is stated that while in service, the petitioner was apprehended by police in connection with BIO PS case number 25 of 2017 and put.
Are you getting a provisional pension?
Provisional I'm getting, but final I'm not getting.
Finally, you will get it. No charge sheet has been filed till now.
No charge sheet has been filed. The matter is at the stage of evidence.
Then how will you get your final thing?
The answer is at my lord, page number 73. If your lordship kindly sees page number 73 for a moment. In fact, 67, my lord. Page 67. This is what the Honorable Supreme Court had to say.
Jitendra Kumar Srivastava.
Yes, my lord. Paragraph 2. Brief and short question which arises for consideration in these cases is as to whether, in the absence of any provision in the pension rules, the state government can withhold a part of the pension and or gratuity during the pendency of a departmental or a criminal proceeding. In my case, there is no departmental proceeding, only one criminal proceeding.
No, because we have a provision in our rules.
Exactly, madam. May I just place that now, if your lordship kindly sees the coordinate bench judgment at page number 100, paragraph 4. I think it makes it crystal clear. Paragraph 4, my lord. Page 100, the coordinate bench judgment. It says, I have heard the learned counsel for the parties and have also perused the materials available on record. As the petitioner is yet to receive his regular pension, the determination of this case has received due importance. The right to withhold or to withdraw a pension or a part of it flows out of Rule 21 of the aforesaid rules of 1969. That is the pension rules. The said provisions contemplates that the right to withhold or withdraw pension and or to order recovery in the event of any pecuniary loss caused by the government, it has to be established that in a judicial, departmental or judicial proceeding, the pensioner has been found guilty of grave misconduct or negligence during the period of his service. In the instant case, and as appearing from the pleadings of either parties, there is no reference to any pecuniary loss suffered by the government, or that there had been any departmental or judicial proceeding where the petitioner was found guilty of grave misconduct or negligence. All that is indicated in the affidavit in opposition is that the pension papers of the petitioner has not been processed due to the dependency of a title suit filed by respondent number 6 and in view of the letter dated so-and-so submitted by government pleader. On this count alone, it becomes abundantly clear that the state respondents is without any right or jurisdiction to withhold the payment of regular pension to the petitioner and or to put on hold on the processing of the pension papers. And my lord, next paragraph, this Jitendra Kumar has been discussed. In the case of state of Jharkhand, this Honorable Apex Court have held that the payment of gratuity and pension are not by way of bounty. It is earned by an employee by dint of his long, continuous, faithful and unblemished services. And paragraph 6, if your lordship kindly skips, it discusses Rule 21. All it says, paragraph 6, it thus transpires that under Rule 21 of the aforesaid rules of 1961, the power to withhold pension, etc., can only be done when a finding is recorded either in a departmental or judicial proceeding that the employee has committed grave misconduct. And the petition was allowed. So, my lord, merely because a criminal process, in my case, there's no departmental proceeding, only a criminal proceeding is pending. Merely because a criminal proceeding is pending against me, that cannot be a ground to deny the pension. That is the sum and substance, my lord. And in fact, this
You are taking it up for final disposal?
I am otherwise ready, my lord.
Okay. But I'll have to reject your case.
As your lordship pleases, my lord.
Because why I'm telling you, that judgment does not take into account provisions of Rule 22.
Yes. 22.
Now, there is a proceeding pending against you. This is not a question of withholding. It's a question that 22 says that the pension will not be released, but a provisional pension and a provisional something other benefits will be given to you. That has been given to you. You say a charge sheet is already pending. A judicial proceeding has come into being.
Yes.
Then how can you?
Now, my lord, the crux of the matter would be.
And you say that it can only be to the extent of loss. Unfortunately, 21 is not worded like that. Worded is grave misconduct.
Grave misconduct. So there has to be a finding either
That
in a
will be to the part of withholding.
withholding. Now,
We cannot call it withholding here because of 2022.
22 deals basically with provisional pension.
No, it says, you read 22 once again.
If your lordship has 22 for a moment.
Please read it for yourself.
My lord. Kindly see Rule 22, 22.1. 22.1 says whether any departmental or judicial proceeding is instituted under Rule 21 or whether departmental proceeding is continued under Clause A of the proviso thereto against an officer or who has retired on the attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of his retirement to the date on which, upon conclusion of such proceeding, final orders are passed, a provisional pension not exceeding the maximum pension which would have been admissible on the basis of his qualifying service up to the date of retirement, or if who was under suspension on the date of the retirement up to the date immediately preceding the date on which he has been placed under suspension. But no gratuity or death come retirement gratuity shall be paid to him until the conclusion of such proceeding and the issue of the final orders then. Now the prima facie, it deals with provisional pension. And if your lordship kindly sees Rule 21 for a moment.
It does not deal with provisional pension. It deals with a situation wherein a person is under cloud. That person will not be released a pension, finalize his pension and his provision and his DCRG and other benefits, but he will be given a provisional pension.
Provisional pension.
And that provisional pension can be the maximum pension also. There is no bar.
There is no bar.
There is no bar.
There is no bar.
But you cannot be given a final pension before conclusion of the proceedings.
Well, that is your lordship's view. But then the view which has been taken by the Honorable Apex Court in the Jitendra Kumar and as follow.
You read Jitendra Kumar part para 2, it says where there is no rule.
Exactly.
Here there is a rule.
Exactly.
We have a rule.
Now that rule has already been, my lord, enunciated by the various division benches. If I may place, I've already placed that Honorable Justice, Mr. Justice Manojit Bhuiya's case. And there's another one of Honorable Mr. Justice, my lord, Hitesh Sharma, S.K. Sharma's. And in both the cases, my lord, Rule 21 vis-a-vis Rule 22 had been discussed.
You show me a case wherein 22 was taken into account. Rule 22 was, because the judgment that you have placed here, 22 was not taken into account.
Yes, 21.
Because the reason perhaps is because 22.1 deals with provisional pension. And 21, if your lordship sees the wordings at 21, it deals, 21, the first few lines, it says the governor of Assam reserves the right to withholding or withdrawing a pension or any part of it. Anyways, my lord, if your lordship feels we should have it after the vacation, we can have it.
We can have it today, no problem. You make your submissions.
So, 34/2023, I had superannuated from service.
When did you superannuate?
34/2023. 34
No, what were you
2020.
working as?
At that point of time, my lord, I was an assistant conservator of forest. (34/2023), my lord, I had superannuated from service. And at the time of my superannuation, I was serving as an assistant conservator of forest.
When were you placed under detention?
But my lord will find, I have made an averment at paragraph 10. Paragraph 10, page 7. During the course of service, my lord, on 4/9/2018, I was arrested by police in connection with BIO PS case number 25 of 2017. Now, there was no DP initiated against me. There was no departmental proceeding against me. Only this criminal proceeding is pending as on date. It is still going on before the learned court below. And we had to come before this honorable court. And once we came before this honorable court, they released the provisional pension. After we approached this honorable court, they released the provisional pension. And I'm yet to receive my final pension as on date.
When was the charge sheet filed in the matter?
Charge sheet.
Lordship, it is on persons on 15/05/2024.
Page 89. Page 89, there's a status report.
The charge sheet was filed on 7/9/2018.
Page 89. Charge sheet, third line. Charge sheet by number so and so dated 7/9/2018 was submitted against the petitioner before the Honorable Court of Chief Judicial Magistrate, Kamrup Metro in BIO PS case number so and so, under section so and so.
Any other facts to be noted?
Well, these are the
You
basic
come
facts.
to Rule 21,
Rule 21.
explanation. Second explanation.
Rule 21. Explanation.
Come to B.
B.
A judicial proceeding shall be deemed to be instituted in the case of a criminal proceeding on the date on which the complaint or report of a police officer on which the magistrate takes cognizance is made. So a report under 173 is the date when a judicial proceeding would be. Now you read 22.
Well, one second. Judicial proceeding shall be deemed to be instituted in the case of a criminal proceeding on the date on which the complaint or the report of the police officer on which the magistrate takes cognizance is
So,
made.
which the magistrate, on which the magistrate takes cognizance,
Takes cognizance.
will take cognizance, is filed.
Is filed.
So a date the charge sheet files,
Hmm.
a judicial proceeding comes into being.
Yes.
Now you read
Hmm.
22.
22(1).
22(1), where any
Departmental
departmental or judicial proceeding
is instituted.
is instituted under Rule 21.
Hmm.
So,
Hmm.
moment the thing is filed, 22 kicks in
Hmm.
and it continues to hold the field till the proceeding is not complete.
Hmm.
Once that proceeding is complete, it will come back to 21. Then it's
Hmm.
the power of the governor to do whatever it is. He can withhold, he can do it.
Hmm.
But here, it's like you are in a continued suspension.
Yes. That is one way. And my lord, the other way is, my lord, under Rule 21, the power to withhold pension, because this is something under 300, Article 300A.
The thing is, Mr. Rua, 22 gives a power. You challenge 22, it'll go. That is not under challenge here. Moment you challenge 22, saying that it is not in connivance with 21 because my pension akin to salary cannot be withheld till the proceeding is complete and a grave misconduct against me is drawn out.
In that case, my lord, let me have my instruction as to whether we'll
Yeah,
need to
we-
challenge
we-
Rule 22(1).
You
Then we'll have to
want
file another writ
challenge, you
petition.
can always challenge. I think we'll close this.
All right, my lord. In that case, my lord, just only my submissions may be recorded.
We'll record.
My lord, my first submission would be, my lord, your lordship will close it, but just my submissions may be recorded. Page 67,
You just put it on a hold.
my lord.
When I reach that stage, you can make the submissions.
My lord, just 3 case laws I'm relying on. All those are part of the record. Those
We'll
three,
take up everything. Don't
Okay,
worry about it. Why are you so apprehensive? Please don't be. Please don't be.
so
But
your
Mr.
lordship is
A.K.
dismissing
Bora,
the matter.
You can have your seat.
My-
Learned counsel for the petitioner. Also heard Mr. J.K. Goswami. You are appearing for Mr. Goswami, you are appearing
So
for
6 and 7, my learned friend will
heard
appear
Mr.
1 to 5.
R. Gogoi, learned standing counsel, Forest Department, appearing for the respondents number 1, 2, 3, 4, 4.
1, 2, 3, and 4.
Also heard Mr. B. Chakraborty, learned standing counsel, AG, bracketed A&E, Assam, Assam, appearing for the respondent number 5. Also heard Mr. J.K. Goswami, learned comment as additional senior government advocate, appearing for the respondent number 6 and 7. The petitioner in the present proceedings, who is a retired government employee, has prayed for the petitioner in the present writ petition has prayed, who is a retired government employee, has prayed for final direction upon the respondent authorities to finalize his pension and pensionary benefits and release to him the dues, the areas thereof. The petitioner has also prayed for a direction upon the respondent authorities. Earn leave?
Earn leave. My earn leave, which was with effect from 24/4/2018 to 3/9/2018, my lord, that has also been withheld. And why it has been withheld has not been explained in the affidavit.
You have got no other leave in your...
No. So, this
No, other leaves, half pay leave, these leaves have all gone.
all gone. This
No, Mr.
second prayer.
Bora, I'm not making this without in air.
Well,
You have any other leave in your leave account? Because this is something which you can encash,
yes,
earn leave.
yes.
And also we'll not go into that. Also to regularize the period of leave of the petitioner, period of absence of the petitioner from 24/4/2018 to 3/9/2018. Also, the petitioner in the present proceedings, while working as an assistant conservator of forest in the, where were you at that point of time, Dibrugarh?
My lord, at that point of time, I was in paragraph 14, page 9. 1 second, my lord.
Serving as assistant conservator of forest, Sonitpur East Division, was placed under arrest on 4/9/2018 in connection with BI down bracket EO bracket over PS case number 25/2017. Also, the petitioner continued to remain under detention till 12/9/2018 when till 10/9/2018 when he was enlarged on bail by the learned additional chief judicial magistrate, Kamrup bracketed M. Also, the petition, you are not placed under suspension at any point of time.
No. And there's no DP pending against me.
The petitioner thereafter resumed his services on 14/9/2018. Full stop. It is seen that the police, on completion of the investigation in the matter had submitted a charge sheet, had laid a charge sheet against the petitioner on 7/9/2018. Full stop. It is stated it is further projected that the case presently is pending disposal before the court of the
Learned Court of Chief Judicial Magistrate, my lord.
Chief Judicial Magistrate Kamrup Metro.
Kamrup Metro.
What is the charge here? AFR. Okay.
Metro.
Kamrup Metro.
Metro.
Judge Kamrup Metro. Full stop. The petitioner not being authorized either a provisional pension and or his pension and pensionary benefits not being the petitioner on reaching the age of superannuation retired from his services with effect from 30/4/2023. Also, the petitioner on his superannuation from service not being authorized provisional pension and or his pension and pensionary benefits not being finalized, the petitioner has instituted the present proceedings praying for the reliefs noticed herein above. Mr. A.K. Borua, learned counsel for the petitioner, at the outset has submitted that the respondents after the institution of the present proceedings has authorized to the petitioner a provisional pension. Also, he submits that the non-finalization of the pension and pensionary benefits of the petitioner pursuant to his superannuation from service is in violation of the provisions of Rule 21 of the Assam Services (pension) rules 1969. Next. Mr. Borua, by referring to the provisions of Section 21, submits that the withholding of pension or withholding or withdrawing of a pension or any part thereof can be ordered only by the governor on a pecuniary loss caused to the government pursuant to the petitioner being found guilty of grave misconduct or negligence during his period of service. Also, Mr. Borua submits that in the present case, there is no order passed by the competent authority under Rule 21 of the pension rules 1969, and accordingly, the petitioner could not have been denied his pension and pensionary benefits that was flowing to him on superannuating from his services with effect from 30/4/2023. Now, next.
My first, my lord, submission is merely because a criminal proceeding is pending against me, that cannot be the ground to withhold my pension.
Then, Lekha. Mr. Borua has further submitted that on the ground of pendency of a criminal proceeding against him, the respondent authorities could not have proceeded to withhold the pension and pensionary benefits due to him. He submits that it is only on conclusion of the said criminal proceedings and the petitioner being convicted therein that the respondent authorities would be empowered to pass orders either to withhold or withdraw completely or a part of the pension required to be sanctioned to the petitioner herein.
And my lord, the power to withhold the pension can only be exercised when there is a finding recorded in a judicial proceeding that I am guilty of grave misconduct. That may be recorded.
After He empowered. He empowered the guilty, convicted the petitioner. He is found to be guilty of commission of a grave misconduct.
And my-
Yes,
And-
next.
And the second submission is, my lord, the Honorable Apex Court, in the case of Jitendra Kumar, had settled, had made it crystal clear. that-
Mr. Barua, in support of his submissions, relies on the following decisions of the Honorable Supreme Court. One,
Only one, that is
following decisions, no, decision.
State of Jharkhand versus Jitendra Kumar
State of
Srivastava,
Jharkhand versus Jitendra Kumar Singh,
reported in 2013 12 SCC 210, wherein it has been enunciated that the right to pension flows out of Article 300A of the Constitution of India.
that we will use it.
Well,
Then, and he further places reliance on the following decisions of this honorable court, of this court.
of this honor.
One,
Number one, it is, my lord, the Birendra Rajbongsi versus State of Assam and others.
can you give me copies of that?
Well, it's part of the record, my lord.
Oh, it's-
Page 99. Page 99.
Page?
99, my lord. It starts at 99.
No, Virendra Rajwa, huh? Reported in
2016 4 GLT
2016
920.
4 GLT 920
Right.
quarterly cast. Next one.
And next one is, my lord, at page number, my lord, 75. Page 75.
Ram Kumar Boisya versus
This State of Assam and others. And the relevant paragraphs would be, my lord, paragraph 8, 9, and
No,
10.
we'll take care of that. 8.
8, 9, and 10. Mary Pushpam, yeah. Citation to কি এটো?
In the above premises, Mr. Barua,
There's one last, my lord. The last submission would be, my lord, the latest honorable apex court judgment, my lord, Mary Pushpam versus Telvi Kurusumari, reported in 2024 3 SCC 224, which enunciates that the decisions of a coordinate bench are binding upon the other coordinate bench, my lord.
even if it is hit by
These are the submissions.
even if it is not passed, if it is passed in ignorance of the provisions of the statute, will that still be binding on me?
My lord, that is what the what
Even by
may I just read out the relevant paragraph, my lord. It says, if the coordinate bench disagrees with the other coordinate benches, the right course of action would be to refer it to a larger bench rather than taking a contrary view. That is what it has
Not-
said.
Has it said that if the division bench, the coordinate bench decision which is relied upon has not taken into consideration all the relevant factors, whether still it will be binding on a coordinate bench?
It says that, my lord, I'll just point out. Honorable Justice Vikram Nath.
Anyway, I'll go through it.
Your Lordship will go through it, my lord. 2024 3 SCC 224.
Okay.
Mary Pushpam versus, my lord, Telvi Kuruswamy. That is my last submission. My last submission would be that coordinate bench judgments had provided relief to the pensioners.
Not our submission. India promises no problem. Talakot, huh? Mr. Barua has submitted that the coordinate benches of this court, having interpreted the provisions of section 21 to mean that before completion of a judicial and or departmental proceeding instituted against the employee, the respondent authorities should not be empowered to withhold and or withhold the pension and pensionary benefits of the government servant, on his superannuation, submits that the same being the position of law insofar as the interpretation of section 21 of the rules of 1969 is concerned, this court would be required to follow the same and or refer the matter to a larger bench for a consideration thereof. In this connection, he has referred to the decision of the Honorable Supreme Court in the case of so-and-so, reported in 2024 3 SCC 224.
And but more particularly, since Rule 22(1) itself has been discussed in one of these coordinate bench judgments, page 76. So 22(1) and 21 both have been discussed, and after considering 22(1) and 2021 and 22(1.
You mean in page, my Lord Justice Sharma's judgment?
Correct, man. Correct. At page 76. So it is not that the court was oblivious of Rule 22(1). When they passed this judgment, it was not in
Where
ignorance
is
of
the
Rule 22.
consideration about 22?
22, page 76.
That's just a passing remark.
Yes.
Where is the discussion?
No, I mean, it says that why not, he was
So it
given.
did not notice 21, it only noticed 21 to the extent of a
Pa-
provisional pension.
Page 76, paragraph 6, if your lordship sees, it says, to be more specific, in paragraph 17 of the affidavit in opposition filed by so-and-so, it is
Yes, sir. I'll only have to go through this Pushpam's judgment and then pass the order. Yes, Mr. Goswami. Mr. J.K. Goswami, Learned Counsel for the, where is your affidavit? Mr. Gogoi, you will have to argue, R.R.
Yes,
Gogoi.
Yes, we file affidavit. Stand is clear and completely in the affidavit.
Okay. Mr. R.R. Gogoi, Learned, I'll just get it what is there, then you add up.
Sure.
Mr. R.R. Gogoi, Learned Counsel for the, Standing Counsel for the, Standing Counsel Forest Department
Forest
submits that. The provisions of Rule 22, bracketed 1 of the rules of 1969, having mandated that where any departmental or judicial proceeding instituted under Rule 21 of the rules is pending against an officer who has in the meanwhile retired on attaining the age of superannuation, such officer shall be paid during the period commencing from the date of his retirement to the date on which upon conclusion of such proceeding, final orders are passed, a provisional pension, not exceeding the maximum pension which would have been admissible on the basis of the qualifying service of the officer concerned up to the date of retirement. He submits that the provisions of Rule 22(1) existing in the matter, the respondent authorities are duty bound to act thereon by act in compliance thereon. So he submits that in the case of the petitioner, a judicial proceeding stood instituted on the filing of the charge sheet in the criminal proceedings pending against him on 7/9/2018. Accordingly, he submits that till conclusion of the said criminal proceedings pending against the petitioner, the petitioner would not be entitled to be released his other pensionary benefits and would be entitled only to receive the provisional pension already sanctioned to him. Mr. R.R. Gogoi has further submitted that the submissions made by the petitioner with regard to the provisions of Rule 21, submits that there is no quarrel with regard to the submissions made by the petitioner with regard to the provisions of Section 21 of the Rules of 1969. However, he submits that the same is only to the extent that withholding and or withdrawing of a pension would be permissible only after employee is permissible by the competent authority only after the delinquent employee is found guilty of grave misconduct on conclusion of the departmental or judicial proceeding instituted against him. He submits that the provisions of Rule 21 has to be read in cognisance, in tune with the provisions of Rule 22 bracketed 1, and accordingly for the non-finalization of the pension and pensionary benefits of the petitioner, the petitioner would not be entitled to any relief as prayed for by him. Yes, what more? Covered. In view of the above, he submits that the present writ petition would not mandate acceptance by this court. I have heard the learned counsel for the parties and also perused the materials available on record. The facts as noticed herein above are not in dispute. The petitioner was arrested in connection with BI bracket EO PS case number 25/2017 on 4/9/2018 and continued in detention till 12/9/18 when he was enlarged on bail by the additional Chief Judicial Magistrate, Kamrup Metro. The materials brought on record also brings to the forefront. A perusal of the materials brought on record brings to the forefront that a charge sheet was filed in the matter against the petitioner. White charge sheet number 10 bracketed A/2018 dated 7/9/2018. The learned counsel for the parties have submitted that the criminal proceeding is presently pending trial before the trial court. The petitioner having superannuated from his services with effect from 30/4/2020, he not being authorized, his pension and pensionary benefits not being authorized to him, although the pension papers were duly submitted in the matter by the petitioner, and he also not being authorized a provisional pension, pending finalization of his pension and pensionary benefits, the petitioner had instituted the present writ petition. The contention of the learned counsel for the petitioner being to the effect that in view of the language of Rule 21 of the Assam Services Pension Rules 1969, the non-release of the pension and pensionary benefits to the petitioner would tantamount to the withholding of the same. He submits that the power of withholding of a pension and or withdrawal of a pension or any part thereof is reserved to the governor of Assam in the manner provided for in the provided for under Rule 21 of the Rules of 1969, which again would be permissible if in a departmental or judicial proceeding the delinquent is found guilty of grave misconduct or negligence Also, Mr. Borua had projected that there being no finding as on date against the petitioner of being guilty of commission of a grave misconduct and or gross negligence, comma, there has arisen no occasion to withhold and or withdraw the whole or part of the pension and pensionary benefits, pension of the petitioner. Pensionary benefits, not pension. Huh? Also, he submits that in view of the above, in view of the provisions of Rule 21, till the petitioner is found guilty in the pending judicial proceeding, the petitioner would be entitled to be authorized his pension and other pensionary benefits. Please.
I wanted to say, my lord, merely because a criminal proceeding is pending against me will not be a ground to withhold my pension. And
the case, the further projection of the Learned Counsel for the petitioner is, I'll just putting it down only, is that on account of a mere pendency of a criminal proceeding, the respondent authorities cannot withhold the pension, cannot delay the finalization of the pension and pensionary benefits of the petitioner and withhold his due, withhold the benefits thereof from the petitioner.
Sorry to interrupt. Because, my lord, such right flows from Article 300A of the Constitution of India.
That is in the judgment.
And my lord, it is
I
earned by
take
the
Learned Counsel for the parties at length. However, hearing remains. I heard the Learned Counsel for the parties. Hearing remains inconclusive. Registry to list this matter again on 15/11 at 15/12/2025. It's just for passing of the law.
Can it be in any other day except 15/12?
16.
16.
I'll just have to go through this.
My lord. Deeply obliged, my lord. Deeply obliged.
But Mr. Borua, sympathies with you, but 22 has to be factored in.
But perhaps we'll have to, when we read, my lord, this is just a discussion, my lord, deliberation.
Please.
In my humble opinion, my lord, perhaps we'll have to read 21 and 22 in the manner which the lawmakers had made.
See, now the matter is over.
Yes.
I had this view.
Yes.
And I had argued this view when I was the other side. But that was in a situation wherein a charge sheet had not come in. Because moment a charge sheet comes in, the definition of judicial proceeding kicks in. And then 22. Otherwise, if there is a departmental proceeding pending, say a FIR is pending, charge sheet has not come, they cannot take resort to 22. They cannot.
But the only thing that is tickling perhaps in your lordship's mind is that charge sheet factor. Fact that in this case there's a charge sheet has been filed.
173.
173.
That is the only thing.
That is the only thing which is bothering your lordship.
That is bothering me.
That is the only thing which is going on. And perhaps, my lord, just thinking out loud,
please,
this judgment of Jharkhand, it doesn't make a distinction between non-filing of a charge sheet or filing of a charge sheet.
No, it says that it says that if there is right, 1-2 lines, because I have considered that judgment earlier.
Just
because that problem is retort to that would be because there is no rules there.
Just thinking out loud, that only thing Jharkhand judgment says is that criminal proceeding, the pendency of, there has to be a finding of guilt, either in a department.
No, that is for your withholding.
Withholding. Either in a judicial or in a department. In my case, there is no department proceeding. Only thing is that that criminal proceeding is pending. Anyways, my lord,
this is all.
It may
we
go.
all tend to make mistakes. Let me make a mistake so that we get the law settled.
Yes. We'll try our best, my lord.
Yes.
Obliged.
And if you find anything more, also, please feel free to.
I'll come. Obliged. Deeply obliged.
Yes.
Pertains to
Hare Krishna, the
reclassification.
name is very pious.
My lord.
And what is the matter?
This is, my lord, pertaining to reclassification.
Land.
From
Yes.
agricultural to commercial, my lord.
Affidavits are ready,
Lot-
affidavits have been filed.
Lots.
My
Everything is ready.
my premium was already, my lord, deposited
There.
in 2001, and the matter has been stuck thereafter, my lord,
May I submit-
because of a notification relating to eco-sensitive zone, my lord. That, my lord, what the government had now brought in record by a affidavit.
Okay,
my
we'll
lord,
have to
A,
consider this.
my lord.
Okay, we have filed one affidavit on 8/12. That is not the record loss. That will be called.
This was that, this is somewhere here.
Panikhati, my lord.
Panikhati,
yes.
There are two areas,
My lord.
two eco joints, whether
Right.
it is in the middle somewhere. This is in the
It's
middle,
also within the Amsang eco-sensitive
Ah.
zone, so there's no dispute about it.
but whether it can be granted.
My
No,
lord, what, my case that I have projected, my lord, in view of the fact that they have said that it is eco-sensitive zone, within eco-sensitive zone, my lord, there are certain activities that are prohibited, which are polluting. Then other commercial activities, including hotels and other eco-promoting activities, my lord, which also falls within the zone of commercial activities, these are permitted. So it is only regulated, my lord, not totally prohibited,
It should be regulated.
my lord. The notification in fact says so, my lord.
Okay. The Learned Counsel for the parties have submitted that the pleadings in the matter is complete. And the matter can be taken up for final consideration. Accordingly, raise to list this matter again on when?
First week of January, my lord.
First week will not be possible. After the use. 22, 22/1/2026.
Obliged.
Yes, who is there for the respond number 7?
I am for the respondent, sir.
You are 47. What is it? What is it? What are you doing? Why this thing? Why the money is not being released?
No, my lord, main thing is that petitioner is the second wife.
Hmm.
And
He is entitled to 50%.
no, this is a Hindu. So as per the Hindu Marriage Act, his marriage itself is void. So she is
We'll
not entitled at all.
We are secular. We'll not.
Now,
We are very secular.
now another thing, my lord,
We are secular.
another
We'll
thing,
not go by Hindu, Muslim, Christ, Israel. We are secular.
and another thing, she filed a succession petition before the learned session judge. That succession case has been dismissed, and which is attained its finality.
Dismissed on what ground? On prosecution.
No, dismissed that
Very-
not maintainable,
Why?
because the petitioner did not arrest as the party respondent the first wife's son and daughter.
That's on a technicality. Yes,
But in any case, the second wife is not entitled at all.
yes, Mr. Sharma.
My
What do you
lord,
say?
My lord, check only for petitioner number 2, my lord, minor son, my lord.
Minor children. Minor children. Now,
In that case, yes, in that case, well, several judgment is there. The
yes,
legitimate or illegitimate children
that will be getting.
that will be getting. But
Devi,
now the
Yogamaya Devi.
only problem here is this, since the succession petition filed by the minor also, that was dismissed.
That is,
But-
we are here. How much? When are you paying?
No, it will, I have to take instruction.
No
Pension-
instructions. if you want to settle it on between yourself, we will provide that. How old is the son?
14.
Now
15 years.
14 years.
So not a
Till
6
till
years.
4 years he will go.
No, you will have to pay him.
18 years.
When was the date of the death of the father?
2014 million.
14. From 14 onwards, you will have to pay.
Yes, you will get the proportionate share only. So
A
let us
proportionate
take
share?
instruction whether they will.
50% proportionate share from 2014.
No, others, the 4 children is there. In respect of the first wife is concerned.
The first wife is a government servant, no?
Yes,
yes.
Got, subsequently, she appointed.
Compassionate
Subsequently, she
appointment
appointed,
also.
yes.
Oh. Then the responsibility goes up. So 50% from 2014.
So just I take instruction.
Okay. Mr. R. Islam, learned.
Legal
Counsel
aid.
represent
Legal aid.
or legal aid counsel representing the respondent number 7. Why is the respondent number 7 not having a, she has means, why should we provide for a legal aid counsel? Why is, what is the requirement? Yes, Mr. Thor. Why should, she's she's a government servant. Why should be given a legal aid?
I do not know, my lord, how she has approached the,
Well, it should not be.
it should not be, my lord.
Lekha, it is brought to the notice of this court that the respondent number 7 is a government servant holding post of what? Working as a grade 4 employee in the establishment of the
PW.
My lord, it is executive engineer PWD Golaghat NH division.
executive engineer PWD Golaghat NH division. So the notices of the present writ petition was served upon the respondent number 7. However, she has refused to enter appearance in the matter. So, although a counsel was engaged for representing the respondent number 7, on account of non-receipt of any instructions from the respondent number 7, the counsel had expressed his inability to represent the respondent number 7 effectively, and the same is recorded in the order dated 19/6/2025 passed by this court in the present proceedings. Who appoints you?
The legal aid committee, Guwahati High Court legal aid committee. Actually, what had happened, I think the respondent number 7 filed an application before the
No, we'll see. The secretary,
secretary,
legal aid
legal aid service committee.
service committee shall consider as to whether the respondent number 7 having a government job and also being in receipt of pensionary benefits on account of the services rendered by her son
He has got everything.
would be required to be provided the assistance of a legal aid counsel in the matter when she has the wherewithal to engage a counsel to represent her. Also, a report in this connection be placed on record on the next date of listing by the Secretary, District Guwahati High Court
Legal
Aid Committee,
legal service committee.
Legal Service Committee. Also, in the meanwhile, Mr. R. Islam, who is representing the respondent number 7, shall receive instructions from the respondent number 7 as to whether she would part with 50% of the pension received by her to the minor, to the petitioner number 2 herein. Also, register to list this matter again on
After vacation.
immediately after reopening of the immediately after the ensuing vacations. We have kept 50% on reserve. The next date we'll see how we can do.
Page 52 is our appointment, my lord. 52.
Wait, please, your lordship.
Yes, Mr. Pawan.
Lordship, record will be required, but council, party council is not available.
We have heard it. We have not called for the records.
And this is regarding Lordship compulsory retirement of the petitioner Lordship. Was working in
This is that matter wherein she had disclosed the details.
Lordship.
We had asked for the records. Where is? The learned counsel for the petitioner is present. However, there is no representation on behalf of the respondent. Mr. M. Sharma is said to be sick. That yesterday there was a mention made.
Another day, Lordship.
Treatment. Also, in view, however, for the ends of justice, raised to list this matter again on
Next week.
28, 2026
Lordship.
for the hearing.
Obliged.
May I please, Lord?
Yes, Mr.
My lord, while the petitioner's case was under active consideration, my lord, with due process, the respondent number, my lord, 8 was appointed, my lord, bypassing every procedure, lordship. His appointment is challenged in this case, lordship.
Who is appearing for respondent number 8?
Nobody, lordship.
Pleadings are complete. No interim order here.
No, lordship.
It is stated that the pleadings in the matter is complete and the same can be taken up for final disposal. Mr. M.H. Ahmed, learned counsel for the petitioner, has expressed urgency in the matter.
Lordship.
So accordingly, raised to list this matter immediately on reopening after the entry winter vacations.
Obliged.
Please, let us pass over for the timing, Lordship. Now, senior counsel, is coming, Lordship. Sir, really, I'll challenge the demarcation notice, Lordship.
This we'll have to hear. As agreed to by the learned counsel for the parties, full stop. The pleadings in the matter, it is stated in that the pleadings in the matter is complete. The learned counsel for the parties have learned counsel for the petitioner has expressed urgency in the matter.
Yes, Lordship.
Mr. Swakia, this matter will have to be heard a bit. We'll take it up immediately on reopening, 5 or 6.
Can be closed also, my lord. The only relief now remaining is that my application for mutation.
Your demarcation is done with.
Yes, demarcation is done.
Done.
Whatever finding is there is there.
There. Now, why should there be a further direction from you? That will automatically follow.
No, Lordship may kindly see my affidavit. In the status, it is shown that demarcation application is pending because of pendency of this case.
Where?
It is my page number 116 minute.
Who is appearing for the other side?
In spite of justice service, he did not appear. That was deemed to be served on 4/12/2025.
Okay. Where is that pendency thing?
120, Milo. 120, it's an additional affidavit filed by us
120?
of our additional affidavit. It's an additional affidavit dated 21/1/25.
Evacuate.
Yes. 120,
Wrong apply.
wrong apply.
What is this wrong apply? Yes, Mr.
Dispute
Goswami.
in the schedule land, Ukta Dagot, WPC.
Dispute in scheduled land. We can understand that.
But it is rejected, Lordship.
Just get that clarification, then they'll go before the civil court.
Rejected is
But
there,
they-
Lordship. Rejected was there.
Court, sir. No, rejected.
So
wrongly dispute in
and so
schedule land.
Solia, sir. But that is but before that, wrong dispute in scheduled land, wrong apply, rejected.
This wrong apply.
No, it is rejected.
Rejected, Lord. Yes,
No,
that is
rejected is
rejected.
the ground mellow wrong apply.
Is this under challenge? This is not under challenge. So if this is rejected, then we cannot ask them to look it. You go to the civil court, get your rights established.
No, my lord, civil court would not come here, my lord. At best, my lord, since he has rejected, I have to go for an appeal, my lord, under the regulation.
Well,
But here the question is, my lord, Uttarakhand WPC 3861 2024 Gusor Solia.
Mr. N. Goswami,
Let them clarify what is wrong applied, my lord.
it is submitted by Mr. P.J. Saikyal and its senior counsel that the application submitted by the petitioner for partition was rejected. For mutation was rejected. This is a mutation application.
Yes.
Was rejected on the following, with the following stipulation. Page 120, A to A.
Or lordship may come to 117, that is the translated version, my lord.
No, it's the, it's a copy koi diba enake di diba. Me ase problem to noy. Komi ase. Ahi jabo to tade. Huh? Photo mani kine logai di. Wait, is there? Only Assamese, it's not Greek. It's Assamese only, it's not Greek.
True, my lord.
Mr. N. Goswami shall receive instruction as to the meaning of the reason assigned as wrong apply dot apostrophe here dispute in the scheduled land and apprise this court about the same on the next date of listing. Wrong apply dispute in the scheduled land. What can we infer from that? Wrong apply.
Application
Now it is Greek.
Otherwise, might not be.
Wrong apply.
Issues of facts are involved, my lord.
No, that we will send him.
And there is
Not-
another
not-
thing.
Not before the
There is-
vacations.
There is another thing, Uttarakhand WPC
Not-
Gusor Soli ase.
You get that instruction, we'll send Mr. Soikia to the civil court, but not before vacations. Let him have the vacations peacefully.
Interim order passed earlier, my lord.
Interim order passed earlier to
No, no,
continue
that's-
till the next date of listing. Why troubling people during the vacations? Don't.
Is this circle officer dispute, my lord? Circle officer dispute, my
No, I don't want to
Known-
trouble you.
known man, my lord. Yes, that's it.
I don't want to trouble you.
Right to get there.
We don't know anybody. We know Mr. Soikia, we know Mr. Borpujari
That's
and Mr. Goswami.
That's true.
Beyond that, we don't know anything.
Obliged. Computers.
Lordship, here, Lordship, the revised result has not yet been declared, Lordship.
Why?
Because it will take time, because the revised result after some, in the month of January, they will declare, because they are now, another process is going on, examination process. That's why revised is
So
equal.
he's been found now qualified in every aspect.
No, he's fine,
So the marks, now he'll have to be placed somewhere.
Lordship.
That exercise is going on.
Yes.
Mr. S.S. Roy, Learned Counsel for the petition for CGC, submits that he be granted further 1 month's time,
Lordship.
for further 4 weeks' time to complete his instructions in the matter and apprise this court with regard to the manner in which the case of the petitioner has been processed by the respondent authorities. Registry to list this matter again after 4 weeks on a date to be fixed by it. Mr. R. Islam, Learned Counsel for the petitioner, is present.
Much.
Here in this case, I am appearing for respondent 2 and 4. Lordship, I have received the instruction. Lordship, may kindly allow me 2 weeks' time to file affidavit.
Pappu Thakur.
After reopening, मतलब date may be fixed, मतलब date.
You will file an affidavit here.
Lordship.
Mr. P.S. Lockhart, Learned Counsel for the respondents number 2 and 4. What are 2? Who is 2 and 4? For
Tinsukia
Tinsukia
development.
and Town Planning Officer Tinsukia. Okay, 2 and 4 submits that he has received his instructions in the matter and an affidavit on behalf of the respondents represented by him would be filed on or before.
On
Give me a
29th.
date.
On 29th.
On or before 29/1/2025. Registry to list this matter again on 9/1/2025. The petitioner is at liberty to bring on record a rejoinder to the affidavit filed that would be now filed by the respondents in the matter, respondent number 2 and 4 in the matter before the next date of listing.
Oh, respect.
My lords, item number 30.
I'm sorry, the government counsel, where is Mr. Goswami?
Can you pass over for time?
I'm being.
Which one?
31 and 32.
Huh?
31.
We'll have it at 2, Mr. You need not
My
wait. The learned counsel is not there. We'll have it at 2.
My
2
lords,
p.m.
my lords,
Please come join back at 2 p.m.
my lords.
31 and 32, Lordship.
31 and 32, yes.
Pass over for time.
31. Where is Mr. Goswami?
And Gusum.
No, B. Goswami, additional advocate general. He was supposed to appear. 2 o'clock. Yes, what is this 31, 32, sir?
The compassion of the
Sorry. Yes. What happened?
Can it be taken up at 2? In your
Get
next
two,
another-
Lordship, okay.
My lord, 33, 34 and 35 may be taken at 2, my lord.
So, madam, we have fixed up much cases. Yes, what is it?
Compassionate appointment, Lordship.
But I'm not in this case, though, sir, my lord, I don't know anything. That is new.
Just a moment, madam, just a moment.
34 is compassionate appointment, Lordship.
Some 35 too.
Yes, Lordship, 33 also compassion.
It's a compassion. It's happened.
Registry to list this matter again on Monday. 15, 11, 15, 12, 2025, 26, 25. enough. Get a. For further hearing.
Lordship fixing any other day, Lord?
Monday,
Monday, okay. All this,
only 32, 31 and 32.
oh, 31, 32 on Monday, Lordship, okay.
No, no, 33,
33, 34 and
33,
34,
34, 35, all these are compassionate upon Lordship.
31 to 35, all compassionate.
Yes, Lordship, all.
Okay, 31, 32, 2 p.m. And 2 hours at Diva.
Lordship,
2
what
o'clock,
this can be
2 o'clock,
taken.
madam,
Yes,
2
Lordship.
o'clock. 2 o'clock. 31 to 35, 2 p.m.
And the case matter pertains to composite land transfer. My lord. In this case, my lord, the
Affidavits filed? No.
affidavit not filed, my lord. And my client wants to during the pendency of this petition, my lord, it is rejected, my lord, during this pendency. And my client visited the circle office. They did not show the reason of this rejection. I'm running pillar to post, my lord. Even this court, before this court also, they did not show the
There is an appellate provision.
appellate provision, but this is, if this is rejected after 45 days. In this case, it was pending still almost 1 year. It was remained pending. Then I have approached before this court, my lord, during the pendency. Now, on receiving the notice, they rejected immediately.
Who is appearing for the respondent? Nobody, government? Mr. Proposer, you are appearing?
I am appearing for the department, my lord.
He says that the matter was kept pending
My lord,
for a year
More than a
and
year.
thereafter it was rejected.
yes.
More than a year.
And the date is of the current date or of that date? Back date?
I have,
Rejection?
I have applied, my lord, on 9/2/2024.
Rejection date is?
Rejection recently, my lord.
So
Recently,
that, then 40, you can always go upon appeal. Who says? From the date of rejection only.
no, my lord. They should, my lord, decided within 45 days.
Huh.
That has not done. That more than 1 year, 1.5 years have been elapsed. Now I have filed this writ petition. Now on receiving this notice, my lord, after issuing order, now they, during the pendency of this writ petition, they rejected it. Before that, my lord, I approached again and again before the office authority, my lord.
There are 2 appeals provided. Yes, will you not be entitled to file an appeal still, Mr. Borpuzari?
That scope
You
is
complete your instructions, come back.
here, my lord, the authority will be the PTC authorities. Because
No, petition.
no, why I am saying so, my lord. It is
Land
my,
is with you.
no, my lord.
No, this is Karimganj,
Tribhuvan district.
Tribhumi.
I have taken a wrong file, my lord. I'm so sorry. Into item?
Item 30.
Yes, 36.
Mr. R. Borpuzari, Learned Standing Council, Revenue and Disaster Management Department submits that he be granted 2 weeks' time to complete his instructions in the manner.
My lord,
Registry to list this matter, accordingly,
yes,
registry to
ma'am.
list this matter again on 7/1/2025.
one of my humble submissions. In the last occasion, they submitted the instruction, but did not show the reason to before the petition, my lord. But I would like to submit that they on earlier occasion,
The Mr. Borpuzari shall also on the next date of application, next date of listing, apprise this court as to the reason for basing on which the application of the petitioner was dismissed, rejected in the Keva Hetu portal.
my lord, the date may be fixed.
7/1.
Okay.
Anything more? Anything more?
And affidavit may be submitted. by
No
the-
need affidavit. We oral instructions will do.
Alternative remedy scope is always open there. I
Get
will come
us
up.
the reason.
I will come up.
You keep it for 1 year. That is a grievance of a citizen. You keep it for 1 year. Why should we not entertain them? We'll see. Yes. Yes,
Your
Mr. Bhuya.
Lordship.
Lord, suspension has already lost its force. My respected friend has on last 3 occasions, my lord, took time to take the instructions, my lord. It is not available. Today, perhaps it is available, my lord.
Yes, what is your instruction?
Pass over the matter for the time being, Your Lordship. Mr. Kyal will appear.
Huh?
Mr. S.C. Kyal will appear, Your Lordship. Kindly pass over the matter for the time being.
Any charge sheet issued?
No, my lord, no DP has been initiated. We have not received any charge memo.
And
the-
this is under 10(3) of the SCCS rules.
My lord, it is a university, yes, my lord.
Or they have their own.
They have their own, my lord, the Central Civil Service Classification
10(1).
Control and Appeal Rules, my lord.
So when was the extension made?
No, extension. We have not.
1/2/25. After that, when
The
was,
extension was not made.
then it's gone.
Lordship, the suspension was on account of assault of a minor, Your Lordship. However, the victim or the victim's family members did not file any written complaint. Because of that, Your Lordship, the charge sheet could not be filed. The ICC committee was also duly formed, Your Lordship. However, due to the absence of a written complaint, no action could be taken, Your Lordship. Now, Your Lordship, if he is reinstated in the university, Your Lordship, it would
Any
create.
criminal case filed against him?
Yes, Your Lordship. POXO cases,
Has a charge sheet been filed there?
I'm not aware of that, Your Lordship. Will have
Can you
to
get the information? A charge sheet has been filed.
No, my lord. My instruction.
Lordship will have to take updated instructions regarding the POXO case pending against the
That
petitioner.
is,
Your
my lord, different aspect that will be looked after, my lord. Even, my lord, this is a very design and a concocted, my lord, allegation against me. Sometimes, my lord, become stricter is very difficult to manage the affairs. So, my lord, the suspension order.
What is the nature of your job?
Huh? Lower division clerk, my
So
lord.
how do you have to be very
When
strict in your?
my lord, allegation to connect.
Lordship,
Allegation is assault of a minor girl.
Minor girl,
Yes.
my lord.
Lordship, as per our instructions, there are proof and evidences against the petitioner establishing.
What
his
are you
bench.
doing? Your
Well-
proof and evidence in your Almira will not do.
Your Lordship, in the absence of a written complaint, ICC cannot conduct proceedings, Your Lordship.
Then you'll have to exonerate him. There is no other way out.
If Lordship could give us some time regarding the charge sheet, Your Lordship will take updated instructions.
We'll take this matter at 3 o'clock.
Yes, Your Lordship.
3 o'clock, my lord.
Much obliged. Your Lordship.
Matter regarding compassionate appointment, but here, my lord, not rejected. Matter is recommended by the DLC, and when matter is pending.
Date of death. Date of death of the father.
My lord, 2010, my lord.
2 p.m.
'39 also, my lord,
Same.
2013 death.
2013. 2 p.m.
They also composite land transfer matter. Kindly see the last order. Last order. Nah. That. In this case also, during the pendency of the petition, it was rejected, madam. Earlier it was under process.
Same thing.
Same thing, but however, kindly see the last order, that WPC 1710/2025, which was disposed of in this line. But I have gone through this order, madam.
Yes, what is it? Tell me.
I have gone through this order. This order was passed when the application was rejected. And in my case, it was under process. It was pendency before the respondent authorities. And it was rejected. When the
This
partial
final Justice M. Chaudhary's order.
Yes, ma'am.
So you say it will not cover your case.
Yes, my lord. Cover means, my lord, mine was under process and it was rejected.
He
On
came after the rejection, you came before the rejection.
rejection, because still under process, because 45 days was.
You go up on appeal. File an appeal, there is an appeal provision there. Why are you not utilizing that? There'll be 101 things required to be looked into. Let them look into. We are here. We'll come up at a later stage. This is not something that it has to be done today only, and if not done, something else would happen. It's not that. You can do it leisurely also. Please have a instruction whether you are agreeable to file the appeal. Agreeable to file the appeal, we close the matter.
And my lord, that may be disposed of by on the line of that order, my lord. Because it is saying that the reasons of rejection should be disclosed, my lord.
They have not given to you.
Have not given me.
That would be a ground for appeal. Yes, what are the reasons? Where do I get the reasons for the rejection?
I did not find what is the reason, my lord. Now they are saying that it is rejected.
Yes, what is the ground
Their
for
instruction.
rejection?
That I do not have any.
Mr. BJ Talukda, Senior Counsel appearing for the respondent number 2 submits that he would receive the instructions as to the grounds of basing on which the application of the petitioner was rejected. We would receive instruction as regards the grounds assigned for rejection of the application of the petitioner in the Seva Hetu appeal portal.
Grounds of rejection.
Next one also same?
Same, my lord, issue same.
40, 41, belek ke maili mein. Rejected 41 also.
It was also under process, but still they did not.
Because they were waiting for you to file a case so that they
Yes,
can.
They did not, my lord, submit anything, my lord. They did not furnish any.
Okay, we'll see.
Lordship has fixed any date, my lord?
No, after the vacations. Or we want to fix it 7-1. We have fixed the other matters 7-1. 7-1. Mr. Chaudhary, the other matters are on 7-1.
Yes, ma'am.
May I please, Your Lordship? Lordship may be taken after some time. Conducting counsel, Mr. Jayavin is on lex in court number 5.
Yes, 42.
Yes, 42.
This is that matter in the morning the mention was made.
No, not this, not that. That is the other one, Your Lordship.
Last matter. Last item.
Full ledger.
When it is fixed?
Please, Your Lordship. Lordship, here petitioner's husband died due to COVID-19. Accordingly, in terms of honorable court's order, they have done all verification in the year 2000, my lord, 27 to 2025, page 37. Have some terms of honorable high court's order. They are found duly eligible.
Lordship, who has forwarded his
Some instruction of. Page 37, my lord, paragraph 10.
Revision of
39.
payrolls. Like revision of pay. Pune ka lage.
The detailed inquiry, page 39, paragraph 10.
Yes, Mr. Goswami, what has happened after
Lordship,
that?
we have submitted a request for sanction to the principal private secretary to the Chief Minister Secretariat, Lordship. That is awaited, Lordship.
This is by the Secretariat or by the Revenue Department?
Well,
Ms. Budley, you have to, COVID, you do it.
That's no.
No, that,
Also, Lord,
this is of that period only.
I'm waiting to communicate. Also,
What was he working as?
My lord, no, he is the widow, my lord.
No. The husband?
Husband was a businessman, but not provided. There was a widow support scheme, my lord.
Oh, not that. No, not that scheme. Okay. Mr. N. Goswami and Ms. N. Bodloy, learned counsels representing the respondent, submit that they be granted further 4 weeks' time to receive instructions in the matter, to complete the instructions in the prayer accepted, registry to list this matter after 4 weeks on a date to be fixed by.
My lord, may I create days, my lord? The widow, my lord, since 2020.
I was under the impression that he is an employee. That we
There-
have,
But there was a
we
scheme.
have pursued the matter with the government and got 2-3 cases.
But here is also there was a scheme.
They were government employees, we do.
Okay, we'll see. Yes, yes, Mr. Kumar.
My lord, my learned
Next
friend
item,
engineer, Mr. Ken Chaudhary and D Das is out. They are seeking for a time on 7th of January.
45 minutes.
7th of January. I say that it is, let it have it on 22nd of January. Because today they were seeking for interim order. They are not pressing for the interim order today.
A prayer is made on behalf of the Learned Council for the petitioners 44-45 Ekalagamariva, on the ground that the arguing counsels are presently not available in the court. Prayer is not objected to by Mr. B.D. Ko, Learned Senior Counsel, appearing for the respondent number 5. And also the other learned counsels representing the official, representing the other respondents. Accordingly, as agreed to by the parties, registry to list this matter again on 22/1/2025.
And pleadings are complete, my lord, and case can be for final.
It is stated at the bar that the accordingly stated at the bar that the pleadings in the matter is complete and the matter can be taken up for final consideration. Accordingly, registry to list.
Can it be on 7th, my lord?
7 to the days.
Okay.
Is having-
Yes, yes, no.
Again, we'll have to adjourn. it.
Yes.
Only for
22nd.
5th till vacation. This time we are lucky. So 6, 7, 8, 9.
You have come back. You had a very short trip.
Well, because I went on Monday, Tuesday, came back. Very
We thought-
scary.
That place you are going, you should stay at least for a week.
No, this time I went alone.
Oh, you went alone. So nobody wanted you there.
No, means, they wanted me,
Ah.
but I need an interpreter to communicate.
Okay.
On 22nd.
So I think the vacations you can go.
Yes. The vacation this time we are going to
Oh, wow.
Vietnam.
It-
10 days. Both husband, wife. No extra luggage.
Is that
In this case, my lord, they have filed an affidavit, my lord.
Ilana Council for the petitioner prays that he be granted further 2 weeks' time to file and what is the issue?
Renewal of the Sonkasha, your lordship.
Oh, 2 weeks' time to file a rejoinder to the affidavit filed by the state respondent. Pray accepted, registry to list this matter after 2 weeks on a date to be fixed by.
Obliged, lord. My lord, any.
Yes, Mr. Singha.
Your lordship, this relates to the pay parity.
Huh?
This relates to the pay parity, your lordship. The feeder cadre, the posts which are lower to us, we are optometrists in BSc, your lordship. This might take a bit 5 minutes of time, your lordship.
No. Where, which department?
Your lordship, finance department was supposed to take a call. May I just submit, your lordship? The issues are like this, where BSc.
No, our medical college. Yes, madam.
Yes, Lordship, I have received instruction, but it's not proper. I need some time to file our affidavit.
No,
Time.
your lordship,
She's only asking for time.
no,
She's not asking for days.
what I'm trying to. No, I'm not objecting, your lordship. Let her take, let my senior.
We'll
take
have
that.
it at 4 o'clock. What is the stand of the government? We'll take up this matter. If you want, or you want to
Okay.
file an affidavit.
Lordship, today.
No affidavit has been filed.
No required, your lordship. Health has already
No,
taken
but
a
I
call. It is up to the finance department. They required.
We have said it to finance
Finance
department.
department.
Yes.
Okay, get somebody from the finance department. We'll see. And Albertasana?
At 2, Lordship.
He's asking at 2 or 4.
It won't be at 2. It'll be a little bit delayed because I have some
Okay.
orders to
Yeah,
deliver.
Lordship.
Yes, first day. GST registration. Yes, Mr. Chetia.
Lordship, otherwise, Lordship, similar matters, Lordship, the petitions were allowed and matter was remanded to the authority to consider. In fact, this is the case, my lord, where, my lord, they have approached the appellate authority and appellate authority has dismissed their petitions. So against that, my lord, further appeal lies. Even then, Lordship, no, Lordship, it was
You come up with a stand if you require.
Otherwise, Lordship, in similar cases, Lordship, they have already.
But there is no appeal filed there.
No, there was no.
Lord, the tribunal is still not there. There is no scope for any appeal out there. And it was dismissed on the ground of delay, on the ground of limitation.
Same
And
the earlier.
yeah, same. Your Lordship has already granted relief earlier. The order is at page number 38. We are praying for a similar remedy out here. Page number 38.
What is your ground for the delay?
Sorry.
What is the ground here for the delay?
Lord, it was medical ground basically. Health issues. I was not even aware of the show cause notice and the order that was passed.
Because it was there in the portal only.
It was there in the portal.
What do you say? Same order?
Lordship.
Consent?
Lordship, only difficulty, my lord, that appeal.
No, if you have something, you tell me, we'll consider. If it is not to be passed, we'll not pass.
Otherwise, Lordship, factually and my lord, the legal issues that is, my lord, covered law.
So merely going before the legal authority, rejection of the appeal has not improved his case. It remains in the same.
Lordship, dispose it off.
We'll take it up. You're here from outside or from here?
I'm from.
We'll take it up. We have from two some matters to be delivered. Judgment orders to be delivered. After that, we'll take up this matter. We'll take it up after. Appeal stands dismissed. Appellant to appear surrender before the learned court of additional session judge number 1 within a period of 1 month from today.
Deeply obliged.
Correction.
Item 2 now.
Appeal stands dismissed. Appellant to surrender before the learned trial court. Madam Bhattaji, you need not wait because we may not be in a position, we'll reserve it before vacations, if possible, we will. If it 1 and 2, 2. See if we go here. Nothing more to be added here. We have got it disposed of. 6 and 7 disposed of. Retail living.
The conducting counsel is still on legs.
Huh?
The conducting counsel is still on legs, sir.
On the prayer of the learned counsel for the parties, registry to list this matter again after the ensuing vacations. Matter be not treated as parted and or tied up matter with this court any further.
Right.
Yes.
Today I escaped.
The man is also on because this is getting delayed now.
Yes, my lord.
Only for you.
But
We are waiting.
today I think, my lord, he has to submit before this honorable court, my lord.
No, he has done. You will have to complete your
Yes,
part.
last occasion, if I remember correctly, Lordship asked the counsel for the petitioner to clarify his stand. And my lord, in any case, my lord, today it has been escaped from my notice, my lord.
Yes, Mr. Counsel.
My lords, on the previous date, my lords, the lordship given a direction to clarify on the construction word which basically used in LOA.
Huh.
My lords, I had a discussion with the purchase team and I have the better understanding now. So, my lords, if we see the LOA, my lords, page number 33, my lords.
The
running
term
page 33.
construction, word construction. there,
Construction.
which Mr.
That's a mere word used in LOA, my lords. So the discussion what we had, my lords, and the understanding which we, after like having a discussion with the purchase team, my lords, what the conclusion comes around with the word construction, that my lords, mere word which basically used in the standard formats. Since my lords, before using that word, my lords, now it's all about the standard formats which basically used in this industry. First part, my lords. Second aspect, my lords, the word, if we see, my lords, the purpose of labor cess is applicable only when the activities carried on under the purview of construction as per section 2(1)(d), my lords. Since there specify the definition itself specify that when any construction with respect to 4 elements and the construction carried out, then only that labor cess applicable. Here in our case, my lords, it's some simple word which basically used in LOA. If we see, my lords, down the line, my lords, in LOA, apart from the subject line, if we see, my lords, starting from bid, my lords, annexure 2, page number, running page, my lords, 30. Clause 3, my lords, 3.1. Again, my lords, before deciding the interpretation on construction word, what actually need to understand the scope of services and the bills which basically I have raised against the activities which I actually have done, right? So, my lords, if we see amenable from bid document, my lords, which annexure 2, page number 30, clause 3.1, my lords, scope of services. Their scope of work under the subject package includes site survey, planning, design, engineering, assembly, manufacturing, testing, supply, loading, transportation, unloading, insurance, delivery at site, handling, storage, installation, testing, commissioning, and documentation of all materials required to complete the DTR metering work in the above 3 packages. Well, this is a scope of service which basically amenable from the bid. Now, it's coming on the amount, quantum involved. Now, this quantum involved in this project is basically 22 crores. 22 crores, 23,000.
22,13,141.
Malus. So that's a basically quantum which actually involved in this project. Now, Malus, on the subject quantum, Malus, what actually I have assigned, if we see Malus clause 12, clause 3, again coming on LOA, Malus, page number 33, my lords.
30?
33, 34.
34, yes. Total price.
My lords, now, my lords, if we see page number 33 and 34, clause 2, award of contract and its scope. Now, my lords, if we see clause 2.1, subclause 2.1, page number 34, my lords, sorry. So, here my scope of service defined under clause 2. What it says that, my lords, that scope of work interrelay includes the following: 3PHW wire LT meeting of existing distribution transformers with necessary accessories. The circle-wise, district-wise breakup of DTR metering works to be executed is enclosed as an annexure 1. That's a scope of service, my lords, which actually specify under clause 2. Now, my lords, clause 2.1.2, which actually been objected by the learned counsel, my lords, that's a subject line actually. It's not confined to the scope of services. That's my first submission, my lords. Now, again, my lords, coming on clause 3, contract price. Now, if we see contract price, my lords, if we see the sub-elements of contract price, which actually defined under clause 3.1, it's bifurcated into 3 parts. First is supply part, second erection part. That's the only part actually it's been bifurcated, for which I've been assigned and for which against which I have to raise the invoice. So the quantum which actually already discussed before, my lords, that's a quantum involved is 22 crores clause. That's again repeated under clause 3.1. where the subject line bifurcated into two parts, supply and erection.
Now, Mr. Counsel, the
My lords.
erection will also mean a construction activity
My lords.
covered under your the supply and construction.
My lords,
What
my
is
lords,
the nature of that erection?
my lords, again,
Because it's a substantial amount. It's around 5 crores plus.
my lords.
What is that erection?
Well, erection is, again, my lords, is defined under scope of services. Since if we see erection part clause 8 of LOA, again, my lords, if we see page number 42, my lords. Since my scope of service is defined, my payment schedule is defined, and the activities which I have to carry it out, against which I have to raise the
What is
invoices.
this erection basically?
Well, erection is something installation, a part of installation. Well, what my scope of service is to supply the meters and to commissioning the setup of the meters which I'm supplying. That's a part of erection. And since the smart meters, they're a process, my lords. It includes heating, it includes commissioning, it includes autopiloting the subject, my lords.
Got
Since
it.
it's,
Yeah, supply part has to be excluded.
my lords.
The other parts have to be excluded. But if there is a construction activity to put the meter in the building, attach it to the building or to the premises,
My lords.
that aspect again it would be covered under the act. Any activity pertaining to the building, a construction activity relating to
lords.
the building will also come within the meaning.
My lords.
So why not for that part? The government is not empowered to take
My
to
lords.
that extent.
Well,
Erection part.
To that extent, my lords, for the
Because
erection,
if you just come down, 3,
My lords.
B1, total cost of FINA charges, erection charges from Schedule 3. Where do I get this erection charges from Schedule 3?
apologies, my lords, page number.
Page 34, that contract price.
My lords.
We just want to negate that this is nothing to do with construction.
My lords, it's though if we see again,
Schedule 3, from
my
where I
lords,
get this Schedule 3, erection charges from Schedule 3.
my lords, though I haven't annexed the schedule 3.
No. You can just tell me what is there. We are not adjudicating on Schedule 3. We just want to understand. Just to negate the plea taken by the other side.
Well, though my scope of service widely elaborated under clause 8, down the line under this LOA, my lords, we see clause 8, where like my activity has been defined and the amount which I have, the invoices which I have to be raised and the amount which actually I'm expecting from the department.
Now you
is
come
there.
to clause 8.1 at page 42.
My lords. My lords.
90% payment against erection part, including applicable taxes, shall be paid on erection, testing and commissioning.
Erection, testing, commissioning.
This testing and commissioning and supply, we understand.
My
But
lords.
what about this word erection?
Well,
What does it signify?
Well, it's a installation basically. Commissioning is where the subject line is to be start operating. That's a part of commissioning. Erection is somewhere like where I got a meter and I have to install.
No, if it is to that extent only, maybe the Supreme Court decisions and all
It's very clear.
will be excluded.
It's very clear. Erection again, my lords.
But we got to know exactly as to what is the intent of that word extract erection and what is the exact nature of work you are required to do under that.
Well,
I think we
erection-
stopped on the last occasion at this stage.
Yes.
So on the last occasion, I have to clarify on the word construction which actually used under LOA in the subject line, my lords. So that's a mere nomenclature which basically use under the standard formats, my lords, in this industry, in this domain. Since if we see the clauses and we are like my scope of services.
We'll
my lords.
try to understand that. Yes, Mr. Sorry. You are the man who has got the work done. What is the meaning of these three terms, supply, construction, and commissioning? What is the meaning of the term construction? And what is the meaning of the term erection?
Construction is itself includes
Yeah,
the erection. Erection is mere installation of those meters only.
Only.
That is what I have instructed.
That is what you have said. There is no construction activity as such.
That is what I have been informed.
কোনো construction erection নাই গেল। ইয়াতো মিটিঙতো বেলেগকে আছে। মিটিঙতো বেলেগকে আছে। চোৱা নাই তুমি ফাইল কৰা এফিডেভিটতে।
He has clarified, Mr. Kans, he has clarified, Mr. Goyal, in your favor. He
Malus.
says that there is no construction, it's only a installation of that.
Malus.
Yes, Mr.
Yes. My respectful submission is, my lord, it would have been cleared if the petitioner would have responded annexure 1, my lord. Case number, my lord, 118.
Oh, now he is before us.
My lord.
He is before us now.
Yes. And in the pleading, my lord, there is no pleading as such that he has not involved in any construction work, my lord. And my lord.
See, Mr. Goswami.
Yes, certain things if I lordship will pass order, my lord.
No. It's not a question of just passing orders. If you had any doubt with regard to the matter, you could have approached the APDCL authorities. They are the employers.
Yes, my lord, but meeting was there, my lord. In the meeting, it was also included. Lordship will consider kindly, my lord. It's a contractual matter. Offer and acceptance is there, my lord. And my lord, the cess was included in the estimated cost. It has already been included in the estimated cost, my lord. And the meeting has clarified, my lord. How my learned friend has so said, my lord, I don't know, of course, my lord. I am only relying the affidavit so submitted already.
Was it done before the contract, the NIT was issued?
Which, my lord?
The inclusion of cess within the contract.
Yes, that is why, my lord. That is why, my lord. In the meeting, your lordship, minutes of the meeting, your lordship will see.
Page 119.
My lord.
Okay. When was the NIT issued?
Yes. Lordship will see, my lord. Last but one paragraph, my lord. The standing council emphasized that when the tender was added to the Janus Power, the cess was already included in the estimated cost. It was further pointed out under the building and other custom workers cess is applicable whenever construction was involved. Additionally, the judgment so
it is not involved, it is not incorporated in the scope of the work or in the taxes leviable to the work before the NIT was issued. The work was completed in 22. Then you woke up. Then you started making all this notices, giving all these notices.
Notices.
They come up and tell you.
Notices were issued only to submit the relevant documents, so that it would have been
this
clarified.
Discussion also, discussion also, the petitioner was there.
My lord.
And he clearly brought on record that, see, there is no construction activity here. So we are not entitled to pay this cess amount.
My lord. But this is the affidavit, my lord, based on which I am making submission before this honorable court.
Fine.
My lord. And my lord,
now you show me that there
in the meeting itself, my lord, it has been discussed, my lord.
Where?
My lord, your lordship, member present listed discussion matter levy lessons so relating to APDCL advance metering infrastructure office of the commissioner labor so. The meeting was very so. The representative from APDCL provided an update on the assumption of metering works across the
Mr. Goswami.
Yes, my lord.
Just come to the second paragraph.
Yes, I'll come, my lord. Upper Assam so, in the lower Assam so, in the contractor working in the 12 district.
Where are you reading?
My lord, that page 119, my lord.
Para?
My lord, this is in fact after the meeting was shared, then the next paragraph, my lord.
Representative.
Yes, the representative for the APDCL provided an update on the assumption of metering work across 3 regions, Upper Assam, Central Assam, so in Lower Assam Power Limited, is the contract working in 12 districts. Their responsibility includes supplying meter, conducting 2-phase and 3-phase wiring, installation of LT circuit, and performing LT metering. In addition to supplying the equipment, Zenas is also responsible for conditioning the system handing over to the APDCL upon the completion. Upon completion, APDCL has clarified the contract for execution of supply, construction and commissioning, distribute, transferring, metering in the is under this turnkey project. It is noted that tax and duties would be deducted by APDCL, which says so and so, so and so. Zenas Power has already accepted the terms and condition. Work was initiated 2000 and completed 2022. The project was finished and the payments for the work were made accordingly. However, in 2024, Zenas Power submitted a letter stating that the project did not envisage any building or construction and therefore it is not liable to pay cess. The Standing Council emphasized that when the tender was awarded to Zenas Power, this cess was already included in the estimated cost. It was further pointed out that the Building and Other Construction Works Cess Act, the cess was applicable whenever construction work are involved. Additionally, the judgment so and so, so and so. It was decided the assessment can order be issued in accordance with this so and so, so and so.
Now, if the cess was included, why did they not deduct that set as that?
My lord.
Why have they not deducted?
My lord, this mechanism, how to deduct it, that part, my lord, I cannot submit before lordship. Only thing, my lord, this was within the estimated cost, my lord.
How do you say that?
That is the, my lord. I'm relying on the minutes of the meeting.
Minutes, okay, but
Yes.
you show me from the.
Yes, my
documents
lord.
also.
He has also nothing he has stated as regards the, my lord, that this is not
for
a
him to say.
construction, my lord.
That is for APDCL to
Yes,
say.
APDCL, my lord, based on his argument.
And the, what I'm trying to point, Mr. Goswami, is if you come to the second paragraph
of, my lord,
that same page, page
Yes.
190.
My lord.
1, 2, 3, 4th line,
My lord,
right hand side. Their responsibility includes.
my lord.
Now, see, just see.
For
Responsibility
conditioning
includes
of
supplying
the
it,
systems, handing over the APDCL.
conducting two-phase and three-phase wiring,
My lord,
installing LT circuits,
My lord.
and performing LT metering.
my lord.
In addition to supplying the equipment, the Zenas is also responsible for conditioning
My lord.
the system and handing them over to APDCL. Where is the
Yes.
construction activity?
My lord, so far supply part is concerned, my lord, that's with regard to that, my lord, I have already made clear, my lord, that for the purpose of supply, no
for the
state, my lord.
No, no. for
This
the
has been considered as, my lord, construction.
How?
That erection.
Just
Now,
show me
how,
that.
my lord, definition that can be, I am not in a position to define all these
You will
things, my
have
lord.
to. You will
But,
have to
my
show
lord,
that in
But
this condition
how it
also.
is not, my lord, petitioner has to clarify how.
No,
it
no,
is
no.
not.
You are now.
Because he has come with a case, my lord, before lordship, my lord. Lordship will kindly consider, my lord.
Petitioner has clarified that there is no construction activity involved.
No, mother, nothing. As such, they have not.
APDCL has clarified.
Yes,
that
but
there is.
this is the affidavit based on which I am making.
No, no,
the
Mr.
circle
Goswami,
submission.
please try to understand the position because I'll have to come to a conclusion.
Okay,
We cannot just leave things in air.
my.
APDCL says there is no construction activity.
If that is so, my lord, based on his argument, my lord. But this is my argument, my lord. This is my submission based
Now,
on.
if you say that the APDCL authorities have said that, we'll record your statement and record his statement and pass orders. for it.
Yes, and my lord, my submission may kindly be
No,
submitted.
you say that it is up to the
No,
APDCL.
up to that, prior to that, my lord, I made my submission, I relying on the affidavit that
Then
erection
you
is there.
satisfy me as to where.
Yes, even
what
if it is,
construction.
even if lordship does not my lord, satisfy on the submission put forward by me, my lord, this is my submission that the erection includes supply as per the condition as, my lord, other day also I submitted, my lord, the clause 2.1.2 execution of supply, construction and commissioning. All these things were included. That I am relying, my lord. Scope of the work, survey, planning, design, engineering, assembly, manufacturing, all these are included, my lord. And lordship, I leave it to your lordship, my lord.
Okay.
In case of building and construction taken by the government, so affidavit, lordship, my respectful submission to rely on the affidavit, my lord. And the finally, what he
So
has
we'll
said,
have to rely on the affidavit and we should not ask any query.
not query, my lord. I have, to the extent possible, I have clarified, my lord. This is included as per my as per the affidavit, my lord. My respectful submission is this is included in the erection, my lord.
That's what
Erection,
I'm saying. If you have to just put a meter in a house, in a premises.
my lord. Not
Then
only
see-
execution of supply, construction and commissioning, my lord, all these things are
Together.
yes.
You cannot charge the cess for supply.
Yes, we cannot.
You
We
cannot charge the cess for commissioning.
Yes,
The only gray area is erection.
erection.
Now show me that erection is something which is tantamounts to the
No,
construction.
has to, the petitioner
They have,
has to
they have,
satisfy.
they have satisfied. They have
Nothing,
said that
no,
no.
they have not, they are not stating, my respectful submission is, they are not stating before this honorable court that this is not erection, erection is not construction, and we have not done anything beyond supply of meters, my lord.
No. They say we have supplied meters, we have commissioned,
My lord.
installed the meters,
My lord,
and
this-
commissioned the meters.
Because the clause 3.1, this is survey, planning, design.
We are not
design.
going anywhere. We'll ask the APDCL authority. Yes, what is your stand?
Only marriage solution of those meters.
No, that-
How? How do you say that? Do you have any instruction to that effect? Can you get a, what is that?
Construction direct.
What does it mean? Exactly, you are the employer. Can you give us at least a written from a competent authority? Tomorrow? Monday. Mr. Goel, we are asking the APDCL authorities to give us in writing as to what they have understood with regard, because that meeting also there is some doubt. What they understand with the word supply, commissioning, construction and commissioning.
Also inclusion of, my lord, that estimated cost as that was included in the, my lord, yeah.
Okay.
That may also be, my lord, clarified by the.
That is for you to clarify.
No,
We are
my
not- we are not
learned
clarifying.
plane has to, my lord, APDCL, Council for the APDCL has to clarify on this.
You stand on your own footing. Mr. P. Goel, Learned
Yes.
Counsel for the petitioner. Right, P. Goel?
Prerit Goel, my lords.
Prerit Goel, P. Goel, Learned Counsel for the petitioner. Also heard Mr. B. Goswami, Learned Additional Advocate General, appearing for the respondents number 1, 2, 1, 2, and 3.
1, 2,
And also Mr. Bidas, Learned Standing Counsel, APDCL, appearing for the respondent number 4. On the next date of listing, Mr. Bidas shall apprise this court about the term supply, construction, Roman and commissioning, finding mention in the letter of award issued to the petitioner. As well as in the LOA issued to the petitioner. The APDCL authorities shall explain as to what the term construction as incorporated in the letter of award with regard to the scope of the work involved means, MEAN. So it is the contention of the Learned Additional Advocate General appearing for the state that the erection involved in the erection activity required to be carried out by the petitioner is in reality a construction activity covered by the provisions of the
NIT.
building workers scheme. Building and other construction workers welfare cess Act 1996. Also, Mr. Das shall also clarify after receiving instructions as to whether the amount required to be paid as cess under the said act was already included in the contract price
Estimated cost, my lord.
And estimated contract price as projected by Mr. Goswami, Additional Advocate General, from the contents of the minutes of the meeting held on 3/3/2025, which is annexed as Annexure Roman 2 to the affidavit filed by the respondent number 2. If he does not have, give him a copy.
Certainly.
Registry to list this matter again on 16. We'll have it on 16. 16.
Monday, my lord.
Tuesday. 16/12/2025. At 2 p.m. would be 2 p.m.
Palace.
We are closing it on that day.
Much obliged.
Yes, when is the date of the death? 17.
38, my lord,
Okay.
38, my lord, 2010, my
Where do I get it?
lord.
Where do I get it?
Yes, sir, it is even in the
Oh,
synopsis.
2010.
Paragraph 4, my lord, is taken.
When was his services regularized? In 2005.
Others, my lord, service. PLC 36, my lord, is recommendation.
DLC recommendation is of you came up before this court.
Yes, my lord. On several occasions came, my lord, and last one, my lord, page 24, my lord.
No. Tell me from before. Then thereafter,
Now, my lord, matter is pending before the SLC. Then, my lord, this office memorandum came, my lord. Office memorandum, at page 41, my lord.
when was it recommended by DLC?
LC recommended, my lord, is 2019, 9, 2023. Page 36, my lord, is recommendation.
Then second case filed. This is the second case.
Good. my lord, problem is that, my lord, because after recommendation by the, my lord, PLC, as per the order of this honorable court, my lord, when, my lord, matter is pending before the SLC, in the meantime, my lord, one judgment came from the honorable Supreme Court, my lord. For, my lord, your lordship is also aware the authority, where it is, my lord, observed that, my lord, when appointment is delayed, my lord, either due to a mistake from this side or that side, no further consideration is not. Then, my lord, on the basis of this judgment, my lord, the state government, my lord, is pleased to, my lord, issue one office memorandum, my lord. It is, my lord, page 41 before your lordship in this petition, my lord. This office memorandum, my lord, they came to be challenged before this honorable court, my lord, in a group of writ petition, my lord. During the hearing of this, my lord, the group of writ petition, my lord, this honorable court found that, my lord, in a blanket manner need not to be applied this notification. Everything is in our hand. Consider each matter, my lord, on merit, my lord. And it is liberty is also given, then you may also apply delay aspect as provided by the honorable Supreme Court in the But this judgment was, my lord, limited to those writ petitions, my lord. Till passing of the judgment, my lord. Thereafter, my lord, this petitioner's case is not to be considered, my lord, as per this notification. Thereafter, my lord, also, my lord, petitioners are coming and filing, my lord. Same leave is given, my lord, to
Look.
consider similarly, my lord. Therefore, my lord, after this judgment of the honorable Michael,
Okay, we have heard it.
my lord, page 43, my lord, this
Similar order.
similar judgment, my lord. So, my lord,
But Mr. M. Barvia,
my lord,
counsel
kindly,
for
my
the
lord,
petition.
the lordship,
I'm dismissing it. I'm
Thank-
giving my reasons.
my lord, kindly, I may be allowed to
Withdraw.
pass over, my lord.
No. Heard Mr. A. M. Barvia, learned counsel for the petitioner. Also heard Ms.
But thing
M.
is,
Das, learned
kindly, my
standing
lord,
counsel.
may I submit another aspect? My lord? Only thing is that, my lord, all other, my lord, coordinate benches are, my lord, passing similar orders, my lord.
Appeal. That is why the appellate court is there, Supreme Court is there. You should try, check up, come back to me. I will modify it.
Before yesterday also, my lord, another.
Mr. Barvia, if you get my order reversed in the before the appellate court, I'm bound by that order. I'll also understand, I will also learn, do that. Heard Mr. Hilana? M. Das, learned standing counsel.
Pass
You are appealing for?
We'll try, my lord, before any other court, my lord. Kindly, my lord, that much, my lord.
On behalf of J.K. Goswami, sir, additional senior government.
You are for respond number,
2, 3, and 5.
Ms. M. Das for respondent number 1,
7, 6,
1, 6, and 7, and Ms.
M. Kalita.
M.
Then, my lord,
Kolita.
may be allowed
learned-
to withdraw, my lord.
Withdraw. After attempting to argue the matter at some length, Mr. M. Barvia, learned counsel for the petitioner, prays that he be permitted to withdraw the present writ petition. It is to be noted that the father of the petitioner had, while working as a regular master roll worker in the office of the executive engineer PWD Rural Road Division, Hailakandi, died in harness on 8/10/2010. 15 years have passed since the date of death of the father. The Honorable Supreme Court, in the case of State of West Bengal versus Devabrata Tiwari and others, reported in Louisville, had held that paragraph had held as follows, had laid down as follows. A paragraph. However, the learned counsel for the petitioner having prayed for withdrawal of the writ petition, the same is not entered into it's not being considered on its merits, and the writ petition stands dismissed on withdrawal.
39 also, my lord, same,
Same.
my lord.
Same. Date of death. Mr. Bonia, date of death,
My lord, kindly, my lord, I have to.
11/1/2013.
My lord, some other matters are also there, my lord, may come another day, my lord.
No,
Not one-
today.
Then I may be allowed to do all those matters, my lord.
Let it reach, we'll allow you.
Lordship, item number 47, we have received a parawise comments, Lordship. I seek 1 week's time to file
Mr. A. Chalia, learned standing counsel.
for the finance department.
Your lordship, may I make one submission, Your lordship? In 2016, the Seventh Pay Commission has made an observation. The observation is at page 203. 203.
Hmm. Hmm.
Para 15, your lordship. Down below, we are BSc in optometrist, your lordship. The feeder cadre or the
Well, how was the, how did the finance department reject this matter?
No,
What are the grounds given?
there was no rejection.
No rejection. They have not
That's what
considered.
I was saying, that there was a categorical direction that the health department will make an in-depth examination and forward it to the finance department, and thereafter in consultation with the same, place it before it. Now, health department has done it. The DME has done it in-depth examinations, and they've recommended a pay of 8,700. And that was forwarded to the health department and accordingly to the finance department. But finance department as on date has neither rejected it, nor accepted it, nor
Do you
expressed
know
their-
the stand now the finance department is taking? Yesterday, we had taken up the issue. They are taking a stand as the pay commission had not made any recommendation. So placed before the next pay commission. So we have taken up the matter with
Lordship, yes,
with Mr. Gogoi yesterday.
yes, Lordship.
So this cannot be. You will have to either consider it on merits,
Lordship, yes.
remand it, get more materials if you want, but you will have to consider the plea on merits because it's in pursuance to a direction or a requirement from the anomaly committee.
But it was the pay commission which has said that.
This is pay commission recommendation.
Yes, your lordship. That's what I was saying. Page 203, para 15.
Okay, Mr. Cholia, what is your stand?
Lordship, there being, right now there are two posts, Lordship, and in the.
What is your stand with regard to this?
Lordship,
Why are
here-
you not giving them?
Lordship, because at the moment in ROP 2000, there is no separate post for BSc optometrist, Lordship. There is no, here for diploma, which that pay grade they're getting, Lordship. But there is no such post as optometrist with BSc qualification. That is why we have asked the administrative department to place it on record, Lordship. The proposal.
Means they were recruited with the recruitment qualification diploma.
Yes, Lordship. Now BSc is there.
He may have, Mr. You have a diploma plus a degree.
No, we are BSc optometrist. We are degree.
Degree. What was the minimum requirement for recruitment to the post?
Your lordship,
Optometrist does not require degree.
yes, BSc, your lordship. There is two, either diploma or BSc. We are
Diploma
BSc.
or BSc.
Yes, we are BSc, your lordship. And one of the petitioner is drawing that scale, your lordship.
And if there is a diploma scale and a graduate scale,
Lordship.
Yes,
the
your lordship.
petitioner is a graduate, how can you not?
Lordship, the issue is there is no. such
Have you
reg-
taken a decision on this?
Not yet, Lordship, not yet. Here, as per, we are yet to take a decision, Lordship.
You'll have to.
Your lordship will kindly, sorry.
Lordship, I'll just say seek some time to file a affidavit.
Your lordship will kindly look at page 43. The advertisement was categorically BSc optometry with work experience.
Mr. A. Chalia, Learned Counsel, Standing Counsel, Finance Department, prays that he be granted 2 weeks' time to apprise, to complete his instructions with regard to the proposal submitted in favor of the petitioners for upgradation of their pay in pursuance to the requirement made in this connection by the,
DME, your lordship.
no, by the which pay commission?
Seventh pay commission.
By the
Seventh
seventh pay commission,
That you make an in-depth examination.
by the seventh pay commission. Full stop. Mr. Chalia shall complete his instructions and apprise this court of the same on the next date of listing. Registry to list this matter again on 19/1/2026.
Lordship.
Mr. Chalia,
Lordship.
reasoned order.
Lordship.
Either way,
Lordship.
you will have to, because this is not a requirement of an anomaly committee. This is a
Lordship,
requirement of
yes.
the,
Yes, your lordship.
kindly look into it.
Lordship.
Heard Mr. S. Sharma, Learned Counsel for the petitioner, and Mr. SC Chetia. S Chetia, Lanark, GST,
CGST, Lordship.
CGST. Lanark Council appearing, Standing Council, CGST. Appearing for the respondents number
2 and 3, Lordship.
2 and 3. Who is for respond number 1? Mr. S.S. Roy. Learned CGC appears for respond number 1. Also, the petitioner, it is the case of the petitioner that he is carrying on a proprietorship business of supply of construction material in the name and style Messrs. MS JMB Traders. Also, the said firm is projected to be registered under the Central Sale Goods and Sale Tax Act 2017, bracketed CGST wide registration number, para 2, page 4, followed bolded years, with effect from 16/8/2018. Also, on the ground of non-filing of his GST returns for a period of 6 months, for a continuous period of 6 months, 6 bracketed 6 months, the petitioner was served with a show cause notice bearing a notice dated 2/3/2023. Also, requiring him to supply a reply within a period of how much? 30 days. 30 days from the date of 30 days from the date of service of the same. Also, it was further stipulated in the said notice that in the event the petitioner fails to furnish a reply within the stipulated date or fails to appear for personal hearing on the appointed date and time, the case would be decided ex parte on the basis of available records and on merits. Also, the petitioner not having responded to the notice as issued in the matter, the superintendent Silcha, superintendent of GST, na? CGST Silcha -2 proceeded wide order dated 2/3/2023 to cancel the GST registration of the petitioner for not furnishing returns continuously for a period more than 6 months. Also, what is your ground? Not service on personally. Notice not served personally.
It was not served.
The petitioner, in the writ petition, the petitioner has further projected that the notice, show cause notice dated 2/3/2023 was not served upon him physically, but was only uploaded in the GST portal. He submits that there was no communication made of any such notice being uploaded in the portal. Also, the petitioner also projects that on account of the ailment suffered by him during the relevant point of time, the petitioner was not able to access the GST portal and accordingly was unaware of the uploading of the show cause notice dated 2/3/2023 therein. Also, he also submits that it is for the said reason that he had failed to submit his reply and also the returns during the period for which default has been highlighted. Also, the petitioner has further projected that later, when he became later, he submits that during the later part of December 2024, when he had resumed his business after recovering from his illness, from his ailments, he found that his GST registration to have been cancelled. You have cleared your dues?
No, sir.
Also, the petitioner thereafter filed all the delayed pending returns till April 2023 and no tax being payable by him, he had only paid the late fines or penalties involved. Also, the petitioner thereafter preferred an appeal under section 107 bracketed 1 of the Act before the Commissioner Appeals. Commissioner bracket appeals on 23/1/2025. However, the said appeal being filed beyond the period of limitation prescribed, came to be dismissed on the ground of delay. So it is under these circumstances that the petitioner has approached this court by way of instituting the present writ petition. Episode para 7, 8, 9, para 9 is ready and willing to furnish all pending returns and make full payment of tax, if any, so, 9, 10, 11, 12, 13, is para 14 required?
Let's to state.
Yes, Lord.
It will be required. Because 24/25 he has not filed. He has filed only till April
Electoral.
Lordship, April 23.
23. So that be the
Lordship.
14, 50.
Lordship may observe if any.
Huh?
Lordship may observe if any.
If any. If required, if called for.
Lordship.
Well, let it be there 24/25.
My lord.
Because he's not having any business in
Lordship.
24/25.
Obliged, my lord.
Yes, Mr.
Lordship, no,
Well,
development proceeding is pending as on date.
development proceeding is pending.
No, not pending.
No criminal case is pending.
Criminal case is charge sheet has been submitted.
Oh, charge sheet submitted?
Yes, Lord.
When?
Date is not there, but number is with me, 85 of 2025.
Get the date. That would be material. Have you extended the suspension?
No,
order?
Lordship.
Why?
Lordship, it was not reviewed.
Why?
Lordship.
Then that is gone.
Yes, Lordship.
Heard Mr. A.R. Bhuiyan, learned counsel for the petitioner. Also heard Mr. S.C. Cal, learned counsel for the respondent. Also, the present writ petition has been instituted by the petitioner assailing an order dated 1/2/2025 issued towards placing the petitioner under suspension. The challenge to the said order of suspension is on the ground that the petitioner has been kept under prolonged suspension without reviewing the order of suspension so issued after the completion of the initial period for which such order would remain valid. Also, Mr. A.R. Bhuiyan, learned counsel for the petitioner, has submitted that no departmental proceedings have been instituted against the petitioner, nor the criminal case instituted against the petitioner, nor any criminal case was instituted against the petitioner in the matter.
No, criminal case was instituted.
Nor the criminal case no departmental proceeding was instituted against the petitioner in the matter. Full stop. He submits that the criminal proceeding instituted against the petitioner is pending at the
Charge sheet level.
He submits that in the criminal proceeding pending against the petitioner, a charge sheet has been filed by the police upon conclusion of the investigation on
27/8.
27/8/2025.
2025.
Full stop. He however submits that the respondent university has not extended or not reviewed the order of suspension of the petition, and accordingly, the same would not mandate any further extension after the completion of the initial period of
90 days.
90 days, 3 months. Also, Mr. S.C. Cal, Learned Counsel, appearing for the respondents number two, three, 4, 5, and 6. That is the authorities of the Assam University has fairly submitted that after issuance of the after placing the petitioner under suspension, while issuance of the order dated 1/2/2025, the university authorities, after completion of the initial period for such submissions, initial period permissible for keeping an employee under suspension, that is for the period of 90 days, had lapsed, no review was carried out in the matter by the authorities. He submits that in view of the fact that no review has been carried out, the initial order of suspension of the petitioner has lost its force. In view of the above submissions in view of the above submissions made by Mr. S.C. Cal, Learned Standing Counsel, Assam University, this court is not called upon to further adjudicate the matter on its merits, and it being admitted that there was no review after the completion of the initial period of 90 days from the date of issuance of the order of suspension, that is 1/2/2025, the said order of suspension has to be held to have lost its force, full stop. Accordingly, the respondent authorities are directed to reinstate the petitioner within a period of 10 days from today. Also, the period of suspension undergone by the petitioner shall be regularized after completion of the criminal proceedings instituted against the petitioner, presently pending before the learned trial court. Also, with the above observations and directions, the present petition stands closed.
Much okay.
Obliged.
Yes, Mr. Abedin.
My pleasure, Lordship. Alright, the issue is regarding after the election of the ward members of a Gaon Panchayat, the election of president and vice president. Alright, my primary allegation was that 2 persons were authorized by the government to conduct the
Affidavit is here.
Yeah, affidavit is there, but one thing is what I have said in the repetition, that is admitted by both the sides, even the private respondent as well as the government.
They are afraid of Mr. Abedin. That is why they automatically.
No, it's not that. They admitted that one unauthorized person was there when the election process took place of president and vice
Even if it
president.
was not there, they will say yes, because you are there.
Not like that, my lord.
Yes, it is like that.
Nowadays-
I can see the fear. Yes, madam, what do you say?
My lord, I file affidavit, my lord. Even respondent number 2, district commissioner also filed a affidavit, my lord. And this
There was an unauthorized person there.
not at all, my
He
lord.
says-
Not unauthorized, my lord. That is the person who is working under the circle officer, my lord.
Why was he there?
It was on 10th of July, my lord. So in Mangalday, my lord.
Now, who is holding the?
My lord, there is no, my lord, discrepancies, nothing, my lord. And instead of
Who
going,
is the president now, Mr.?
Yes, president is from
Uh,
the side.
respondent number 10, my lord.
9.
Sorry, 9. And 10 is the vice president, my lord.
My lord,
And only, my lord, only 10 members are there, my lord. And 10 members have
Okay,
voted.
where is your statement to that effect, Mr.?
which one, my lord?
That the person, unauthorized person?
Yes, my lord. My lord, I'm coming to this. Only one thing, if your lordship looks at the second order from this honorable court, when the instruction was sought, the instruction was given from the circle officer against whom the entire allegation, and this court also, my lord, verbally opined that you are The allegation is against the circle officer. How can you get the instruction from the circle officer? And the entire affidavit is based on the circle officer's report. But if my lord, before I go to my writ petition, if your lordship looks at the
No,
affidavit of the respondent
What
number
happened to
9,
the appeal file?
my lord,
Appeal filed by you?
yes,
yes, my lord.
This is with regard to president and vice president
Yes,
selection.
Yes,
Yes.
yes, my lord.
So if something happens there, there is a provision in the
Yes, section 11, my lord.
11 of the,
Panchayat, yes.
this is
That-
Jila
that-
Parishad or Gaon Parishad?
Panchayat.
Yeah,
Gaon
they
Panchayat.
should have approached DC, my lord.
Deputy Commissioner.
Yes,
here
yes,
is here.
my lord. Wrong, my lord.
That I filed.
Hey, so. There is a clear-cut provision, if I remember.
My lord, there is an order also, my lord, passed by the honorable court, my lord. On 26th of August, my lord.
My lord,
Any dispute relating to the validity of election of the
Yes.
president and vice president of Gaon Panchayat under this act shall be decided by the deputy commissioner.
Yes, my lord.
Annexure 10,
Yes.
page 50.
Annexure?
Annexure 10, page 50.
What happened to this? They have not taken it on board.
No.
Why? Yes,
And
Mr.
Another interesting thing, my lord. Over here, in this appeal, I made categorical allegation that this circle officer called an unauthorized person. And interestingly, the what respondent number 9, who is the president now, how can he say this, my lord? Just look once, my lord. My lord, paragraph,
Paragraph? Affidavit by respondent number 9.
9. I think that is page 60.
No, you tell me.
My lord, paragraph 7.
Paragraph 7, yes.
My lord, paragraph 7, how can he say that this is the individual?
This has not. Last order.
Now see the authorized officer, page 41, annexure 5. Clear cut authorized officer is given by the deputy
By
commissioner.
deputy commissioner, no
Yes.
order.
The authorized officers are page 41, annexure 5 of my writ petition.
Let us see the provisions of Rule 46 of the Constitution rules.
Yes, my lord. My lord, 213, if this book.
You all are updated. We are still in that old age.
No, sir.
Where is your allegation that this unauthorized person who was brought there purportedly to write down the minutes had also influenced the voters in
Yes.
the election?
Yes, my lord.
Where is your statement?
My lord, my lord, page 12. Paragraph 12, page 11. Incidentally, he was a Lat Mandal who belongs, his residence belongs to that.
So the persons who were authorized was Tonoy Bora and Madhujjo
Madhujjo.
Narzari.
Yes, my lord.
And this gentleman, respondent number 4, is the resident of that Gaon Panchayat, my lord, where the members are elected and the election was to be held.
How many votes did you get?
My lord, it was,
Total, my lord, 10 votes.
my lord, only thing before, it is 4 and 6, but
You got 4.
I got 4, but 5 petitioners are before my lord. My lord, what happened? 5 petitioners are before my lord. What happened? The ballot papers are bought
You
by
are
the.
also one of the 10.
Yes, yes.
Yes.
My lord, the ballot papers are bought by the authorized officer. He has written down the 10 ballot papers, but there is no serial number. We are not onto that. What happened, my lord? After casting the vote, the room was locked. It was opened by themselves, by 3 of them. They counted and then they opened.
Not in your presence.
No. And they said the result. My lord, how long for this so many days, how 5 petitioners are before my lord? If the 6 of them casted the vote in favor of that motion, my lord.
Oh, that is possible. That day they cast, after that they have
Agreed, my lord, agreed.
casted them away and
No, but the
aligned with you.
No,
That is different, but that is of no use.
My lord, fact remains that this unauthorized, when your lordship has seen that notification, my lord.
Yes, who is for the deputy commissioner?
Deputy
Yes,
Commissioner
sir.
says the same thing.
Why? This all process being done in this manner?
Lordship,
What is the allegation?
Lordships in our affidavit were clearly stated in paragraph number 8, Lordships,
From where? Who has filed the affidavit?
by the deputy. Commissioner.
Deputy Commissioner.
Deputy commissioner himself.
Yes.
Yes, my lord.
My lord,
Okay.
paragraph 5 is important.
Lordship, I think, my lord, that record is put.
My lord, if your lordship look at the deputy commissioner's entire affidavit, as per report of the circle officer, the person against whom my allegation is, and then paragraph 5, my lord, I don't know how this
Okay, why was his application not considered? The appeal submitted by him, why was it not considered? You have not said anything in the affidavit?
In the affidavit, Lordship, we are nothing there. I mean, paragraph 12, Lordship. Regarding the that appeal has been filed. Paragraph 12.
My lord, even before even disposing of the appeal, my lord, they have approached this honorable court, my lord.
see paragraph 11. My appeal has been sent to that person against whom my entire allegation.
That is not, that is regarding opinion, asked to that the circle officer.
Over there, the question of
Lordship,
appeal is there.
Alexa, see, Lordship, may kindly see that.
Yes.
Where was it? I found it somewhere. That circle officer, deputy commissioner has forwarded it to the circle officer.
Lordship, annex,
Page
see,
56.
Lordship, page 67, Lordship. Factual report, Lordships.
Is
That's
this
because
the-
my lord, he was at the, that.
Is this the way the statutory power given to the deputy commissioner is being exercised? He has to take a independent view upon hearing the parties.
Lordship, that
Because if the allegation is against a particular person, the deputy commissioner continues to rely on him.
Lord.
What would be the sanctity, at least in the eyes of the,
It's because, I think, my lord, that at that time of that first meeting, Lordship, that the circle officer was present. My lord, that's why, my lord, he was asked the circle officer to submit the factual report.
both the president
already,
and the
my
vice
lord, he was
president is
authorized.
before us? Both the president and the vice president is before us.
Lordships.
We'll dispose of this writ petition requiring the deputy commissioner
To dispose.
to issue a notice to all the concerned within a period of 10 days, schedule a date of hearing, hear everyone, including the appellant, the petitioner,
Petitioners and
the elected candidates, and any witnesses. Witnesses cannot be more than that 10.
Lordship.
Within that 10, whoever wants to depose will depose and thereafter take a call.
If necessary, my lord, only one thing, it's okay, my lord. If necessary, then deputy commissioner may go for the election among the 10 members, my lord.
No, not again, my lord, not.
No,
again.
yes, it has to be, because that is my
Not
prayer.
That is why I say this side it is 786, that is AI computer. It
Yes.
thinks very ahead.
My lord, what is AI?
My lord, in the affidavit we have filed by the.
AI does not know what AI is. That's the interesting factor.
The petitioner never replied as the affidavit.
Oh. But Mr. J. Abedin, learned counsel for the petitioner. Wait. Respondent Gita.
My lord, one more thing, can I submit my?
Yes, madam.
Petitioner number 2, he has already joined the, my lord, the present committee, my lord, present panchayat, my lord.
Who?
He, the petitioner number 2, my lord.
As
He has joined the meeting, my lord. They have taken over charges, the new panchayat, my lord. They have already taken, my.
No, no, no.
No,
That is
they are working, my lord. They are
that is a
working, they are
different
working on.
who is the
my lord.
president?
President is the, respondent number 9, my lord.
Who is the vice president?
Vice is 10, my lord.
10.
And petitioner number 2 is one of the petitioners here.
They are part of that committee, otherwise
My
also.
lord. Others, my lord, others petitioners have not joined, only the second.
Oh, not joined, no, not participating.
Yeah. They have participated. He has participated in the meeting
That will,
as well as in other schemes also.
that will not make any difference.
And my lord, out of 10 votes, my lord, cannot be any, my lord, discrepancies, my lord, by the respondent number 4, my lord.
Also heard Mr. Who is for the Panchayat? Mr. K. Kwant, learned additional advocate general, as standing counsel. Panchayat and Rural Development Department. Mr. S. Bothakur, learned counsel, affairs, Mr. J. Handik, learned government advocate for the respondent number 2.
2 and 3.
2, 3. Mr. S. Bothakur, learned respondent number 4. Who is for 5?
My lord, 5 is the thing already.
5,
Five.
secretary, my lord.
Madam, you are appearing for?
6
6
to 10.
to 10, my lord.
Ms. Bora, MS Bora, learned counsel appears for respondents number 6 to 10. Also, the petitioners in the present proceedings has put to challenge the resolutions dated 10/7/2025 adopted by the Nagarbahi Gaon Panchayat
Nagar Panchayat.
towards electing the respondents number 9 and 10
10, yeah.
as the president and vice president of the Gaon Panchayat in a meeting for the purpose conducted by the respondent number 3 and 4, who were authorized for the purpose by the deputy commissioner, jurisdictional deputy commissioner. Three. By 3, huh? Only 3. Respondent number 3, who was authorized by the deputy commissioner for the purpose. Also, the petitioners have the petitioners in the writ petition have contended that the election of the president and vice president of the Nagarbahi Gaon Panchayat stood vitiated on the ground that the respondent number 3, who was the authorized officer, had involved in the process of the said election an unauthorized person, that is the Lat Mandal of the area. The petitioners project that the presence of the Lat Mandal and the influence exerted by him in the election process had led to the results being unfavorable to the petitioner. The petitioners have also prayed have also raised further issues in the matter. Also, the learned counsel for the respondents have, learned counsel for the respondents number 9 and 10 have had categorically denied the contentions raised by the petitioners in the matter and has submitted that the election was held in the manner required, and it is only after the petitioners could not garner the requisite number of votes in the meeting that they have now instituted the present proceedings. The learned state councils, by referring to the pleadings brought on record, have submitted that the respondent number 4, who was brought to the meeting by the authorized officer, that is the respondent number 3, for the purpose of his convenience in recording the minutes of the meeting in Assamese, had in no manner participated in the election process, and the allegations leveled by the petitioners in the matter are without any substance. Also, the contentions raised by the petitioners in the writ petition and as well as in the pleadings brought on record, as well as the submissions made by the learned counsel for the parties today at the hearing of the matter, it is evident that the issue arising in the present proceedings pertains to the election of the president and vice president of Nagarbahi Gaon Panchayat. Also, a dispute admittedly arising with regard to the process of election carried out for the purpose of post of president and vice president, this court notices the provisions of Section 11 of the Assam Panchayat Act 1994. The provisions of Section 11 being relevant is extracted here in below, page 28, Pura 11 to. A perusal of the said provision would go to reveal that any dispute relating to the validity of election of the president and vice president of a Gaon Panchayat under the provisions of the Act is to be decided by the Deputy Commissioner. Subpara. The petitioner herein has already approached the Deputy Commissioner by way of submitting an appeal under Section 11 of the Act of 1994 on 23/7/2025, and the same is a pending disposal. The grievance expressed by the learned counsel for the petitioner, the apprehension expressed by the learned counsel for the petitioner is to the effect that the respondent number 3, who is to dispose of the appeal dated 23/7/2025, has sought for a factual report from the respondent number 3, against whom the petitioners have raised allegations with regard to the manner in which he had conducted the election process. Mr. J. Handick, learned counsel for the petition for learned government advocate appearing for the respondent number 3, has opposed the said submission and has contended that the same was only for the purpose of understanding the views of the respondent number 3 in the matter, so as to come to a conclusion with regard to the allegations raised by the petitioners in the appeal filed by them before the respondent number 3. Be that as it may, without entering into the merits of the matter, given the express provisions of Section 11 of the Act of 1994, this court requires the Deputy Commissioner, Darang Mongalre, to take on record the appeal, the application submitted by the petitioners under Section 11 of the Act of 1994 on 23/7/2025, and thereafter issue notices to all the 10 panchayat members elected to the Nagarbahi Gaon Panchayat, including the respondents number 9 and 10 hearing, The Deputy Commissioner shall also issue notices to the authorized officers. So, such notices shall indicate a date schedule for hearing of the matter. On the scheduled date of hearing, on appearance of the parties to the proceedings, the Deputy Commissioner shall permit each of them, shall permit the petitioners as well as the respondents number 9 and 10 to bring on record their evidences in a manner as they deem fit and proper. So, on such materials coming on record, the Deputy Commissioner shall proceed to consider the same and dispose of the application preferred by the petitioners on 23/7/2025 by issuing a speaking order. Also, the further steps that would be required to be taken in the matter, if so required, shall be so taken by the Deputy Commissioner, the District Commissioner, in terms of the decision that now would be arrived by him in the matter, in terms of the directions passed here in above. With the above observations and directions, the present writ petition stands dismissed. Disposed of.
Lordship, the time period.
The said exercise shall be completed by the petitioner, by the respondent number 3, within a respondent number 2, within a period of 3 months from the date of receipt of a certified copy of this.
3 months.
3 months.
Obviously, my lord, so many.
How many you will have to give evidence, you will give cross, you will cross,
Yes, my lord.
cross for.
No. What I'm saying, as long as the Deputy Commissioner takes, that is another thing, my lord. Only thing, the initial date, my lord, that is
I
important.
said completion within a period of 3 months from today.
Completion.
He'll complete it within a period of 3 months, not the other way around.
3 months is also too much, my lord. Let it be 2 months.
No, my lord, the government.
Why 2 months? Let it be 1 month, let it be
Department,
15
my
days.
I would have said 1 month, but as your lordship is saying 3 months, that is the reason I said in between 2 months, my lord.
You are so considerate. We are learning daily.
I leave it to your lordship, my lord.
3 months. They have also come in, let him also enjoy some power.
The interim restriction is there.
Oh, the interim orders passed. Order, there is interim order here.
Kind of a interim order.
Where?
For disposal, my lord, disposal of the
There
petition.
is
my
no
lord.
bar for disposal. Oh, that one.
That's all, I think.
Any observation made by this court in the present proceedings touching upon the functioning of the Gram Panchayat shall not be in force with effect from today.
Deeply obliged.
My lord, if it is, my lord, interim order is passed, my lord, your lordship will pass the interim order, not to be imposed, no? Okay. my lord.
You want the other way around? You want the other way around? I can do that.
Not at all, my lord.
No
I thought
problem for
everything
me.
will be stopped, my lord.
No problem.
Obliged, my lord, obliged. I was so scared.
এইটা সিরিয়াল কিটা মোটা 30 পৰা কিমান আছে 31 পৰা Where is Mr. Barvia?
It's in 24.
He wants to withdraw everything. No problem for me. It will save my work. That's all. I get a disposal, but at the same time, I got to do nothing. Very good.
Can be taken after some.
Okay, we'll take it up after some.
My lord, item 33, 34 and 35
Just a moment.
may come up on Monday, my lord.
No, today. No
Then-
carrying forward on Monday.
Then-
33, 34, 35, madam, you are there. Okay.
Yes, my lord.
Yes.
My lord,
33.
these matters are covered by this order, my lord.
Please give me. Madam, can you give me the date of death? Okay, we'll consider. Where is the date of death?
Date of death, my lord. The
In
first
item
one,
number,
first one, my lord.
item number,
First one, item 33, my lord.
33.
Date of death is 1/9/2016.
So, yes, what is your,
Then the petitioner applied for compassionate appointment, and his case was placed before the DLC, and the DLC recommended him against specific post, my lord, page 30, my lord, annexure C, my
where
lord.
is the meeting of the minutes of this state level selection?
2017.
State level selection committee?
State level, my lord, a list was prepared for sending before state level committee, but by that time, my lord, the OM, my lord, dated 2024 came up.
We'll have to follow this. But Ms. S.B. Chaudhary, Learning Council for the petition. And the other two cases also same,
Yes, my lord.
no SLC.
No, my lord.
Sure.
But a list is there, your lordship may kindly see, a list was prepared for
Okay.
sending. to
Whether
SLC.
they applied lordship.
Yes,
under
my
the
lord,
name.
they have applied.
If they have applied lordship, this will take its own course, lordship. As per the SOP lordship.
Even
The
if I dismiss it,
applications were called for lordship.
This
If
is
they
other
have already
petition.
applied lordship.
The other day, they appeared and they, my lord, submitted that all the cases will be considered.
then why are you pressing?
Yes,
Go
lordship.
ahead.
This is
Last, my lord, this is the order, my lord, your lordship may kindly peruse. The order I have furnished, my lord.
This will take its own course, lordship. Huh. Last para, lordship.
Heard Ms. S.B. Chaudhary, Learning Council for the petitioner. Mr. S.B. Chaudhary submits that in terms of the, what do you call that? Guidelines. What is that guidelines? Guidelines.
Yes, lordship, this 3/4/2025 order, lordship.
In terms of the order dated 3/4/2025 issued by the.
Single bench, lordship. This
No,
one.
no, no,
My lord,
the
yes,
SOP.
Notice, my lord.
Notice in terms of the.
38,
notice-
Has been dated 30th August 25.
38, 2025.
The petitioners have already applied,
Yes, lordship.
have already applied in pursuance thereof. And their cases are presently pending consideration. It is to be noted that in the present case, the recommendation was made in favor of the petitioner by the district level committee. However, the same was not considered by the state level committee, and during the pendency of the same, the state level committee was abolished by the state, by the respondent authorities by the issuance of office memorandum dated 18/9/2024. So, in view of the above position, the petitioner having already applied
Yes.
in pursuance to the said order office notice dated
38, 2020.
2025.
comma. This court is of the considered view that no further adjudication would be called for
Yes.
in the present writ petition, and the case of the petitioner would be considered on its own merits
Yes.
and by taking into on merit and by taking into account the applicable case laws, applicable decisions of the Honorable Supreme Court, including the decision of the Supreme Court in the case of State of West Bengal versus Devabroto Tiwari and others. So, with the above observations, the present writ petition stands closed.
That's for number 3, 5, 6.
Because if I come in, I'll have to dismiss it, so it will be a problem.
Yes,
for you.
lordship. Because they already have applied lordship, it will take its own course.
33, 34 and 35, my lord.
33, 34, 35, same also, my dear. Mr. M. Bhattaji and Mr. J. Miss M. Bhattaji, M. Bhattaji and Additional Senior Government Advocate, and Mr. J. Handick, learned Standing Council Revenue appears for the state respondents. Yes.
Deeply obliged.
But in all these cases, none cases the SLC has considered.
No, my lord.
It
was
did not go up to the
It
SLC.
is not placed.
Okay.
Only a list was prepared
Okay,
for
ma'am.
sending
Okay,
before
okay,
SLC.
okay. 4-5. It was, 31, 31, 32. Date of death, 31.
Well, 31, this is the similar matter, my lord. Their case, they also applied before the SLC, my lord.
No. Whether their case was considered by the SLC earlier.
No, my lord.
Huh?
No, my lord. Same, my lord, this is my lord. Pending, my lord.
Yes, madam.
But death is in 1999, Lordship.
1999?
Yes, Lordship. Item 31.
Oh,
This also. has
you have
been
applied in
looked into,
pursuant to
Lordship.
Yes,
that.
my lord.
Withdraw this. Otherwise, no issue. I'll have to dismiss.
My lord.
No, that is only 2017.
Yes, 16.
17.
Yes.
I've gone a bit soft. 16, 17. Not 99.
Yes.
You withdraw it, you have applied, let them consider. I'm not saying.
Already applied, my lord.
On Mr. A.M. Barbhia, Learned Counsel for the petitioner submits that in view of the subsequent developments taking place in the matter, he may be permitted to withdraw the present writ petition. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, the writ petition stands dismissed on withdrawal. 32,
32, my lord.
31, 32.
32, my lord, died 16th, my lord.
16. 16,
2016.
it ordered you. But SLC considered.
No, my lord, this is pending before the DLC.
It's pending before the
Dear-
DLC.
dear Lordship.
Why, you,
If they have applied Lordship, it will take its own course. Lordship.
it ordered you. Yeah, go to it was a notice or case to.
Like 34,
It is
35 Lordship.
17/12/2016.
This is of 2016, Lordship.
Ah,
date.
that's right.
Yes, Lordship.
Now some compassion has developed. So. But don't think for the court.
Actually, my lord, I failed to recollect. Your lordship passed already one order taking Devabrata on board, my lord, to consider, my lord, as per the spirit of the Devabrata by the DLC, my lord.
What I'm doing.
I'll get, my lord.
Now I will not only the spirit, now I will imbibe Devabrata Tiwari into me and pass the order. 4-5.
My lord, 39, my lord, this is died on, my lord, 2013, my lord. It is
13.
39.
Withdraw.
39, my lord, before the SLC, my lord.
39. Withdraw.
My lord, it is died, my lord.
A.M. Barbhia, withdraw.
My lord, 39 one died 2013, my lord.
13. No. 13,
Apply, my
no
lord.
compassion. 39, withdraw. Anything more?
38, 39,
31. এটা যে আগত withdraw কৰিছো। একে হ'ব।
38, 39 would do.
38 and 39 withdraw.
4, 5 also would do, my lord.
4-5 also withdraw. Very good.
Applying.
So, Mr. Barbhia, you have withdrawn 4, 5,
38, 39.
38, 39, 31, 32.
31, my lord, one dispose of, my lord, this is.
16 is 32.
Dispose of
Yes,
Lordship.
32 disposed of. ঠিক আছে? এর বাকি 4, 5 disposed of. মানে withdraw.
32 dispose of, my lord.
32 disposed.
Applying.
Yes.
Deeply obliged, Lordship.
Yes.
Against the termination, my lord, that was. The respondent was to submit today, my lord, regarding that.
Yes. We heard this matter.
Yes, my lord.
Yes.
Yes, you wanted to say something.
Yes, my submission was that natural justice has prevailed in his case because he participated in the inquiry, preliminary inquiry, which was conducted by the ADC. Subsequently, and he had submitted a reply to that also. Subsequently, when show cause was issued, he submitted his reply to the show cause. And thereafter, when it was found unsatisfactory, his services were terminated.
Okay. That accredited engineer.
Yes, my lord. Yes, my lord.
When was this contract otherwise would have expired?
His initial contract says
No. The contract which was in currency on the date of termination.
no, there was no contract on the
There was
date of
no contract.
termination. No.
Just continuing.
Yes, they were continuing because
When was the last extension?
the only contract.
Mr. Ghosh, I wanted that information only from
No,
you.
there was no extension only. With the only contract which was signed by them was the initial contract. After that, the
When was that?
is that page
To page 13 of the
page
petition.
13, Lordship.
From
Second March 2019,
For a period of?
1 year.
After that, there was no contracts.
No, the authorities wanted to get them into contract, but few of the contractual engineers agreed it. They denied. They didn't want to get into a contract.
So,
Well, if they are continuing in their job, my lord, the salary is paid accordingly.
heard Mr. A.Y. Chaudhary, learned counsel for the petition, also heard Mr. A.K. Ghosh, learned standing counsel, PNRD department.
Lordship,
Mr. Ghosh has submitted that the initial contract entered into with the petitioners at the time of their, the contract entered into with the petitioners at the petitioner at the time of his initial engagement for a period of 1 year was thereafter not extended. He submits that the petitioner services were terminated after he was given due opportunity to bring on record his defense in the matter. And it was only after the consideration of the defense raised by the petitioner in the matter that the order of termination came to be passed in his case. So, Mr. A.Y. Chaudhary, learned counsel for the petition submits that he be granted a week's time, 2 weeks' time to make his submission, make his submissions and to make submissions in response to the stand taken by the departmental authorities in the matter. Registry to list this matter on 7/1/2026 for further hearing. Not dismissing it because.
My lord, otherwise, my lord.
No, vacation.
I admit, my lord.
Trouble.
Otherwise, my lord, the learned friend, what he has submitted, my lord, that is, I have the strong objection regarding this. On the basis of the preliminary inquiry in the back of me, my lord.
Oh, you make your submissions, Mr. He has just brought his stand. You make any submissions,
my lord,
you'll have to convince me with decisions.
2019 onwards, I am being a employee, my lord, I am
Sir,
sitting there.
Chaudhary, you will have to convince me with decisions of the Supreme Court in this connection.
Any date may be given within.
7/1. 7/1.
May-
Otherwise, your vacation will go. You will have to prepare appeal in the vacation.
I am penniless now, my lord. Your worship knows
Still,
that.
you enjoy.
so that inquiry was not backhanded. He's
Oh, we got it. We'll have it. We just give Mr. Chaudhary a breathing space.
Can it be within December, my lord, any date?
Very tied up. Mr. Chaudhary, you should understand the mind of the court.
Yes, yes.
So just try to
Obligement.
work out something. There is a way out. You work it out.
Please, Lordship.
Read a bit more.
Yes, ma'am.
Huh. এটা আৰু আছে 40 কিমান ৰবা নহয় এইটো অৰ্ডাৰটো মই দিব লাগিব না এইখিনি মাৰা হ'ল নে নাই মোক দিয়া নাই দেখোন কপিটো মাৰি দিয়া নাই এইটো দিয়া নাই কিয় Heard the petitioners at length, heard the parties to the proceeding at length, registry to list this matter again on Monday. I'm sorry, that type part did not come. Is it time? Anu quickly over. It by slip quid Monday.
Further hearing or lordship in the.
Further hearing, further hearing.
Oblige.
I'll finish it here. None appears for the petitioner on call. Mr. D. Deca, Learned Standing Counsel, AIDC is present. For the ends of justice, registry to list this matter again after the ensuing winter vacations.
Obliged, Your Lordship.
Yes, there was some dispute here. That consent was given, consent was not given.
Lordship, Lord.
What happened?
Lordship, consent was not given, Lordship.
This is also again with regard to a election of a Gaon Panchayat.
Yes, Lordship.
President and secretary.
Lordship,
President and
member,
vice president.
member, Lordship, member.
Huh?
Member, Lordship. Papahibari Gaon Panchayat member, Lordship.
What is your grievance here?
Lordship, it is unfair election, Lordship. Unfair means have been,
No, how can we do that? You will have to go before the Panchayat election tribunal.
yes, sir, that is the point, Lordship. This interesting point here. As per section, as per 127 of the Assam Panchayat Act, they have to, government has to constitute election tribunal in every district, Lordship. In Hudai district, Lordship, there was no election tribunal constituted, Lordship. Only one, notification was there from the year 2000.
It is constituted now, Your Lordship. It is
I'll
notified.
go.
It is notified now.
Yes. On the day of, Lordship, on the day of filing this writ petition, Lordship, there was no election tribunal constituted in the district of Hudai, Lordship. So there was no any other alternative remedy than to come to this court, Lordship. And there was, Lordship, this issue was, in respect of this Panchayat election, this issue was raised before this honorable court. And this honorable court has passed an order, Lordship. I would like to refer only one paragraph, Lordship. Lordship, this page number 25, para 54 of this judgment, Lordship. This court judgment regarding election, Lordship. There was multiple writ petition, Lordship. I would like to read out the relevant portions of the para 54, Lordship. Page 25. Non-entertainment of writ petitions shall not, however, preclude the petitioner who are contesting candidates or had submitted nomination paper to contest the Panchayat election to avail their remedy under section 243 Constitution so 129B of the Assam Panchayat Act, other than the petitioner number 1 in WPC so. The other petitioner would not therefore be precluded from filing election petition before the jurisdictional Panchayat election tribunal within the stipulated period of limitation. Insofar as the petitioner number 1 is concerned, he can explore the possibility of filing the writ petition only after declaration of the result. That means there were some candidates, so they have to go to the tribunal, and those who are not candidates, they can file writ petition after the result is concerned. That is the thing. Here we are, here petitioner number 1 and 2 are not candidates, and petitioner number 3 and 4 were candidates. So far as petitioner number 3 and 4, there was no election tribunal constituted in Hudai. And so far as petitioner number 1 and 2.
Now, that situation would arise in a case wherein say no candidate had made a challenge, but some outsiders who are outside the purview of the candidate, they say, so they can't go before the tribunal.
Yes.
So the High Court said, okay, fine, you file writ petition here.
Yes, Lord.
Now, if there is a candidate willing to challenge the process of the election,
yes, sir,
then why should we have two proceedings, one here and one there?
Lordship, I have filed my 1 and 2 are not candidate. I can file writ petition, Lordship. So far as 3 and 4.
At the same time, if 3 and 4 wants to file a election petition, why should we consider the writ petition here?
Lordship, so far as 3 and 4 are concerned, at the time of filing, there was no election tribunal.
I'm not on that. Today, why should we segregate 3 and 4 and ask them to file an election petition and continue to examine this issue by petition number 1 and 2? Why should we keep this writ petition? If you have filed an appeal, file an appeal. Get your election petition done away
Lordship,
with.
so far as 1 and 2 is concerned, they can't go to the tribunal.
But 3 and 4 can go.
Of
Or
course,
same issue, why should we also entertain? Yes, Mr. Monto, what would be the position? If election petition is to be filed by 2 of the petitioners because they are candidates, It's permissible under the Panchayat law. One and two are not the candidates.
They cannot challenge.
They cannot
They
challenge.
can
So,
point or entertained by this court only.
but at the same time, when the election petition is,
Two parallel.
why should two parallel proceedings?
That will be difficult.
Think
Because-
over this.
Because your target is same.
Target is same. And see, it may be contradictory.
Lordship,
We may say no, the tribunal may say yes, because it has
They are definitely-
advantage of evidence.
Lordship, so far as 1 and 2 is concerned, they can go to tribunal, Lordship.
They can't go, but 3 and 4 can go.
3 and 4 can go, but so far as
You
1
are in
and
the
2 is
same
concerned.
boat.
Because so far as this is not only our grievances, not in respect of the counting, Lordship, in respect of total unfairness. We have filed the representation challenging that.
That is an issue which would be the basis for the election petition.
Lordship, just I would like to refer
Yes.
only one, Lordship. Page number Annexure 2, Lordship.
My only issue is that why two proceedings on the same target?
Lordship, Annexure 2, my representation, wherein I have stated, I have given about 49, Lordship. 49
No,
persons.
those would be
named,
evidences
out
now.
of which many are
Those
dead.
would be the material that 3 and 4 will now utilize.
Yes.
And you will be witness. In the list of witnesses, you will be there. As number 1, 2, that Mr. Ullah knows better than me how to do it.
But Lordship, my perception is that even if this 3 and 4 can go to the tribunal, the right of 1 and 2, who has
I'm
approached this
not on the
honorable court?
question of right, Mr. Ullah. I'm not on the question of right. I'm on the question of propriety. Now see, the same very issue we will consider. We are also saying the tribunal to consider. Now the tribunal takes up the matter, evidences and all. Say, I go against you. I'm
Yes.
just giving up. I said, no, on this basis of material, I cannot. But the tribunal tomorrow, on the same basis of the material, it comes to a conclusion, no, the election is vitiated. Now, I having here held that the election is not vitiated, how will the tribunal proceed? It cannot, because my order is binding on the tribunal. See, that is
Yes,
the
yes.
technical issue
Yes.
I'm not doing anything today. You think over the matter.
Okay, Lord.
There is somebody also waiting in the wings to file an affidavit. We will not deny him filing an affidavit. No. Affidavit needed.
Go through 243O.
No,
Yes, yes.
your junior said that you have to file an
Yes,
affidavit.
but because of the controversy between the advocates, I decided not to file. I'll go for the legal,
No.
legal pleading. Madam.
You are there, naturally things would be sparking everywhere. So we can't help it, Mr. Abidin. We have to bear it. You file. But examine this issue.
Yes, sir.
Only on that. Not on the right. I'm on the
Yes.
propriety.
I have gone through the law, but allegations are somehow, it's like corrupt practice. And the only thing is the election petition.
That is different.
No, entire allegations. You can say like, my lord, it is within the.
Bring
domain.
it on your record. Bring it on record. Heard Mr. D. Ullah, Learned Counsel for this is item number
63.
D. D. Ullah, Learned Counsel for the petitioner. Also heard Mr. K. Kumar, Learned Standing Counsel, Panchayat and Rural Development Department, Ms. Esther Roy, Government Advocate, and Mr. J. Abedin, Learned. And Madam, you are NB Kaista, Learned Counsel, appearing for the Learned Ms. MB Kaisto and Mr. J. Abedin, Learned Counsels, appearing for their respective respondents. So, Mr. Abedin submits that he would file a preliminary affidavit in the matter, raising an objection with regard to the maintainability of the repeat. Let the affidavit be filed within a period, on or before. On or before 19/12/2025. Raised it to list this matter again on 18? Right? On 7/1/2026. Registered to list this matter again on 19/1/2027. 2026. So, the learned counsels for the parties shall address this court on the next date of listing. Okay. So let's just keep this in mind.
Okay.
Just for our guidance, what you can bring on
Yeah.
record.
Instead 7 and
9, done. See, we are so broad-minded, so
oblige, Your Lordship.
Mr. Monto, what are you waiting for?
Item number 56, my lord.
Yeah, ma'am.
Settlement matter, my lord, settlement order, my lord, they have to produce the record and 1 year settlement period, my lord, already more than 5 months has gone, my lord.
Oh.
Probably Panchayat is appealing. 56.
56. Steps. Raju Das. This is settlement.
Bi-weekly market, my lord.
Private respondent has appeared.
Appeared, my lord, number 7.
Yes, what is your ground, Mr.? I'm sorry, I did not.
No, my lord, actually, what happened, my lord, your lordship kindly straightway go to my lord, page, my lord, 26, my lord. So my bid was rejected, my tender was rejected on account that, my lord, it was above 10%. My lord, after 0.30, no negligible, my lord. My lord, it is different only, my lord, 0.00086. After 3 point, my lord, is always, my lord. That is the only one count. And another count, my lord, that my lord, person who was selected, although it by lot, he has not produced any document, my lord. Lots of document, my lord, he has not been produced.
Which is the one? Raju Das we got.
Yes, Raju Das, my lord, your lordship, yes.
26 we
Yeah,
got.
he's the petitioner here.
Now, where is the private respondent?
Private respondent number 8, my lord. Your lordship kindly see.
7.
Private respondent number CL number 8 here. Next page, my lord.
Ziadul Islam.
Yes, my lord.
Okay. Now, what is his? He has offered
Documents, my lord,
30,
he's
55.
not Bakija certificate, not the debt clearance certificate, affidavit, etc.
What was the minimum value, that government value?
No, minimum, my lord, your lordship kindly see, I am hit by your lordship kindly see page 26, my lord. Page 29.
77, 600. This is the average bid value.
Average bid value, my lord, if it
The
is.
NIT, what is the rate?
No, your lordship kindly see the NIT, my lord, it is not mentioned, but it is mentioned.
No.
My lord.
Moriabari bi-weekly market?
Yes, my lord.
27, 77, 600.
My lord.
Where is the condition with regard to 10%?
That is page 29. Page 29. First column, my lord. Settlement value, any asset should not be exceed 10% average settled value of the 3 years in the so and so. So your lordship kindly see what is my exceed, my lord. Page 32. Normally, my lord, after 3.0, after 0.3, my lord, that is negligible.
Oh. And the value of the private respondent number 7, his value is?
No, his value is all right, my lord. But the other document which are required to be filed by the mandatorily be required, my lord, that has not been Bakizai certificate and other, my lord.
Where do I get that?
That is your cohesively your lordship will find from the my lord comparative statement. Serial number 10, 15, 16, 17, 18. This is a, sorry, from serial number. Column number. Keep blank. That's why record was asked to produce, my lord.
Yes,
Lordship, sometime maybe given for.
My lord,
we are
already.
here till 5 o'clock.
No, your Lordship, the.
What is this?
On Monday.
Records are being called for a long time, Mr. Kumar. Why is your officer?
On Monday, your Lordship.
Tomorrow.
Monday, your Lordship.
Tomorrow.
Lordship.
Tomorrow.
We
This
have to-
order was passed on 3/9/2025.
Your Lordship, on my Friday, your Lordship, may kindly take up.
Friday,
On
tomorrow.
Friday.
Friday.
Friday, your Lordship.
Friday. Oh,
Yes.
today is Wednesday.
Wednesday.
Okay, okay. Mr. Learned Council, Standing Council, Panchayat and Rural Development Department submits that the records required to be produced before this court would be furnished by him on Friday. Registry to list this matter again on Friday, Tariq to DDB, as a fixed item. Fixed item.
My lord, develop.
If you have, if you have urgency, because if it gets to the second half, maybe we'll be in problem. So first half, you can make a mention,
My lord.
subject to convenience of Mr. Kumar,
My lord,
upgrade the matter.
my lord.
The
Develop.
records only we'll have.
Yes, yes.
Only that.
We'll only have to see the records. What is your stand? You know better. Why are you keeping mum? Have you given all these documents?
Submitted, my lord.
Everything?
Is not required.
Huh?
Not.
So far as the documents with regard to the grant is concerned, it's not required. Because when the grant is required, my lord, supposing, my lord, the landed property, which I mortgage, the valuation of the same is equal to or more than my settled value, then grantor is not required.
Then guarantor is not. So that is gone.
My lord, property which I have not raised, valuation of which is more than the settled value.
Oh,
Why?
then next point.
Next one, Pakistan.
Ah.
That I said, as per my instruction, that I have submitted, my lord. Why the competitive state is reflected that not submitted, that I don't know, my lord. So for
Oh,
instruction, I received my
okay.
client.
Pakija certificate issued by?
Issued by my lord.
The authority.
The DC office, Morigaon. This is the, that I don't have any Bakiza case. This is the certificate.
That is dated.
24/6/2000.
The original will be in records.
Yes,
the
sir.
records. And third point,
The third point same, my lord, that is the grantor.
grantor. Second point, first point grantor, second point Bakisai.
I did not mind.
Third point what? Third, which is the deficiency, number 3.
Pakistan certificate, debt clearance certificate, guarantor affidavit.
The grant.
Grantor affidavit, forget it. Then debt clearance certificate,
Debt clearance certificate.
Grantor.
Oh.
Not necessary.
Not necessary. Then
This Bakistan certificate, debt clearance certificate,
Bakiza certificate.
and my lord, these are all.
these are the 2 points.
Yes, sir.
No, my lord, other points are also there, my
Yeah,
lord.
they tell
And then
me.
some short follow-up document that I'll point it out, my lord. Because my lord.
So if these documents are available on record,
Then my lord,
we
yes,
will have to discuss the risk. Okay, because the rates are not very material here.
Yes, my lord.
Okay. And if we don't find the documents, we are interfering with the.
My lord, deeply.
No, just for my sake, that to understand that I can keep the case. That's why I just wanted.
My
to
lord.
Oblige, your Lordship.
May I please, your Lordship? My
Hmm.
lord, here, my lord, the petitioner's father had expired in 2016, and my lord, his case was placed before the DLC, my lord, 22, my lord, 2022, and DLC.
Went up to the SLC.
No, my lord. My lord, DLC, my lord, though placed, my lord, but they held that he was eligible, but there was no post. So it will be placed before the next DLC, but not placed the next DLC. The petitioner had approached dishonorable.
16.
Yes, my lord.
Have you applied against that in that
Recently, yes.
notice?
Yes, my lord.
Okay. Hey, etu yak diriba. Gotomo, Govino. Dispose kora jitu order ase tat lagai dibo dibo. M. Adi. K. Goswami. K. Kadit. K. Goswami. And they apply to it 38 notice. তাতে consider হব। দেৱব্ৰত dispose কৰি। Date of death হল, date of death,
11/06.
date of death, Mr.
Date of my lord 11/6/16, my lord.
11/6/16.
Obliged.
Dispose of. What was it?
Lordship, here in this case, Lordship, I have to file an affidavit, Lordship. Affidavit not filed, yes.
We have not prevented you, Mr. Goswami.
Lordship.
Okay. On the prayer of Mr. J.K. Goswami, learned counsel for the petitioner, for the respondents. A learned additional senior government advocate appearing.
Standing counsel,
Or standing counsel.
Animal Husbandry and Veterinary Departments.
Yes, what is the grievance?
The grievance regarding a compensation claim against the death of the petitioner's son by breaking house wall of husbandry department, animal husbandry department. 43 impugn order. my lord.
Where is the speaking order?
43 page.
43.
Mr. J.K. Goswami, learned standing counsel, AH and Veterinary Department submits that the affidavit on behalf of the respondents represented by him would be filed on or before 21/1/2026. Registry to list this matter again on 30/1/2026.
They were supposed to bring certain instructions. Your lordship will kindly peruse the order dated 19/11/2025, your lordship.
19/11/2000.
2020.
Huh?
19/11. First order, your lordship. Para
Yes, who is on the?
Para 10.
You're so afraid of me.
Your lordship.
Mr. Roy wants to come up, but again, he is a bit apprehensive. Should you not?
ZA, your lordship.
Ah.
Our case is that, your lordship, they have decided to start new Shakti Sadans, your lordship. And this is just to subvert the Honorable High Court's interim order, your lordship. They have done it, your lordship. Your
The
lordship,
earlier round of litigation.
your lordship may kindly come to page 83.
Who should respond here? Government of India.
No, your lordship.
State government.
State government. Social welfare. In fact, your lordship, they are not paying us, your lordship, our dues, we are entitled to, your lordship. And on the one hand, they are not paying that, your lordship, not submitting the.
Yes, Mr. Nath. Who will appear here? Director of Women and Child Development.
Lordship. Let me have the instruction, lordship.
Oh, you should have had it by now.
Lordship. And in fact, your lordship, there is a observations that interim prayer will be considered this date, your lordship.
Lordship, let it be on Friday, lordship.
Tomorrow. Or day after.
Friday.
We'll have it on Monday.
Lordship, Monday, your lordship.
Sunday. On the prayer of Mr. S.S. Roy, learned government advocate appearing for the respondents. Registry to list this matter again on Monday. Not right, no? As per Thakur, learned counsel for the petitioner is present. So, on the next date of listing, the learned government advocate shall complete his instructions with regard to the contentions raised by the petitioners in the petition for being granted a interim direction.
Deeply obliged.
I should raise it to list this man. Baki keeping report. Yes.
My lord, on the previous day, an order was passed requesting the registry to take note of the amended petition. The amended petition was put in. If an order will be passed by my lord to kindly allow us to amend the cost title is necessary.
You have filed it.
We have filed it.
Notices were issued. No.
No, not yet, my lord.
No, this new respondent. Notices should not be issued to him.
No, not yet.
Not yet issued.
Not yet.
Seen the office note dated 3/12/2025, which reveals that the petitioner has filed an amended cost title by incorporating the name of the newly impleted respondent number 3. Subpara. We'll issue a notice on respondent number 3.
In fact, my lord, 4, my lord, also, my lord, is not there now. In fact, my lord, that committee, the interim committee was to be constituted by the respondent for the government, my lord, not by the council, my lord.
Oh.
Now election has been held, my lord, 6 members, elected members are there. But my lord, that, so far as the, my lord, ex officio members are concerned, were to be appointed by the, my lord, government.
Wait 1 minute.
Probably you will have to take steps.
Mr.
R. Singh.
Hmm?
R. Singh.
R. Singh, learned counsel for the petitioner. No, the learned counsel for the petitioner to take steps for service of notice upon the newly impleted respondent number 3 by way of speed post steps within 2 working days from today. Also, Mr. B. Gogoi, learned counsel representing the respondents, has submitted that the respondent number 4 is no longer holding the post of charge of the post of Principal Secretary to the Government of Assam, Health and Family Welfare Department. Mr. Singh submits that he would take requisite corrective measures in this connection before the next date of listing. You are registered to list this matter after 4 weeks on a date 2 weeks.
My lord, we have filed this interlocutory application praying for modification of the honorable court order at page number 14, my lord, 14 in the IA. The honorable court, while passing the order, my lord, directed that the impugned notice dated 16/5/24 shall not be given effect to, my lord. But the 16/5/2024 notice was issued by the applicant Lakhimpur Municipal Board, my lord. In fact, the land in question, it was settled. If lordship kindly comes to annexure 1, page 10 of the IA. It is settled in favor of the municipal board.
Now, should be the notice date? What is the challenge in the petition?
The notice has been challenged, my lord. They said that the land doesn't come within the jurisdiction of the municipal board. It is outside, it is a village land outside the jurisdiction of the municipal board. And on that ground, my lord, they have challenged. It is a government khas land, my lord. Admittedly, it's a government khas land. They have no right to occupy the land, my lord.
It is seen that the service of notice on respondent number 4 is complete. Accordingly, list this matter after service of notice upon. Yes. 16/5/2024.
16/5/24, my lord.
16/5/2024. What is, that is the prayer in the writ petition.
Yes, my lord. 16/5/24, kindly, that is a notice, my lord,
Annexure
issued
4.
at page 21,
Huh.
Annexure 4.
Huh.
The board has issued, executive officer, board has issued the notice to the petitioner,
Hmm.
is at serial number 2.
Hmm.
We have directed them to remove.
No, what
the
is,
prop-
why is it modification required?
Lord, the land has been, that particular land where the
So
shop
there is no
starting-
error in this order, otherwise. Typographical error has not occurred. Okay.
No, we have paid for vacation.
Yes, what do you
vacation
say?
order.
Want to file an affidavit?
Sure, I'll.
Let them file an
Not,
affidavit.
not chief.
I thought that there is some error in the.
No. Not.
Heard Mr. D. Nath, Learned Counsel for the petitioner, issue notice, returnable 4 weeks. Mr.
M.I. Hussain.
M.I. Hussain, Learned, Counsel accepts notice on behalf of the opposite party number 1. Ms. N. Bodle, Learned Counsel accepts notice on behalf of the performer respondent number 2, while Mr. S. Roy accepts notice on behalf of the performer respondents number 3 and 4. No formal notice is to be issued. As all the parties are represented, no formal notice is to be issued. Raised it to list this matter again. Well, Mr.
If possible, on 9th of January, my lord.
9/1/2025, the petitioner, the opposite party number 1 is at liberty to bring on record his objections before the next date of listing.
Obliged. All right, my lord.
Gida shake me. Yara shake me. Okay. In the office note dated 4/12/2025, service of notice upon respond number 8 is deemed
I'm appearing for respondent number 8.
8 is deemed to be complete. Ms. R. Devi has entered appearance on behalf of the respond number 8. Accordingly, raised it to list this matter for admission hearing after the ensuing winter vacations. Parties are at liberty to bring on record their respective pleadings before the next date of listing.
Court has already filed affidavit, my lord.
Whoever wants to. Parties are
Prayer is limited to send the matter.
not today.
My lord, highly
I've had enough.
Yes, my lord. With your lordship's permission, my lord, as instructed by Mr. Raichara Choudhury to move the case, my lord. My lord, over here.
Hope he is not, he is fine.
Yes. My lord, entire case is paragraph 13 and 14.
No disposal, no disposal.
My lord, similar direction, my lord, of that earlier case. Over here also, I filed my appeal. Page 48, Annexure G.
Raised it to list this, as prayed for by the parties, raised it to list this matter again on Friday.
Deeply
They are also human beings. They'll also have to.
I understand, my lord. I understand.
My lord, continue.
54 interim.
Yes.